David, could you give me a sound check?
Are you talking to me, Doug?
Yes, I am. I've got a problem here. I'll be back
Okay.
with you.
Hey, David, this is Sandra. Is there an echo when I talk?
There is not. It sounds good.
All right, thank you.
Yep.
Hey, Fred, can I do a sound check? Can you hear me?
I can hear you just fine.
Thank you.
You bet.
Your Honor, I wanted to see if there was an echo now. Is there an echo?
Well, the echo was coming when I spoke. I don't hear it
Okay.
now, and I don't hear it now.
All right, I think we solved the problem, but please let me know if it comes back.
Will do.
Thank you.
Mr. Court Reporter, are you there?
Yes, Your Honor, I'm here.
Did I hear that there was an issue?
I just, yeah, it's fine.
I'm sorry, you're all set now?
Yes, I'm all set now. Thank you.
Okay, good. I don't see Mr. Yeager. Has anyone spoken to Mr. Yeager this morning?
Marcus Drummond, I've spoken to him. I received an email from him earlier this morning. Simply saying that his voice wasn't a whole lot better today and he didn't know how much he'd be able to participate, but I think he'll be joining us shortly.
Okay, I see that Mr. Yeager has been able to join us now, so we're going to get started. We're back on the record in case number 9499. Couple housekeeping matters. I would, Mr. Bugelmans, if you could provide me with an estimate of the amount of time that you anticipate you'll need with KCPA witnesses, and then I believe there's two. The county witnesses, I believe there are three, and then the town witness. I would appreciate it. It doesn't have to be right this minute unless you're prepared to do that.
I'm prepared to do it now. We are not anticipating many questions. We reserve the right to ask questions, but I don't anticipate from our end it's going to be extensive.
Okay, I have the same question for you, Ms. McLemore.
It's not going to be extensive, maybe 15 minutes for Miss Lewis and maybe 10 minutes for Miss Friss. Are you talking about KCPA specifically?
Start there, yes, and then please move on to the county and the town.
We'll probably have about 20 minutes for the county as well, maybe 10 minutes for the town.
Okay, thank you.
Thank you.
As I said yesterday, it's a hard stop at noon on Friday, so we'll start at 9 on Friday, unless that gives anyone serious heartburn. We can also start at 9 tomorrow in the interest of getting this completed this week. Does that give anyone a problem?
Staff
Present a
would
problem for
support
anyone?
that. Staff is fine
Okay.
with starting at 9, Your Honor.
Okay, so we will start at 9 a.m. tomorrow and also on Friday. Again, hard stop at noon on Friday, regardless of where we are. And if we need to continue into the following week, we will. Tomorrow,
Yep.
council. Yes.
I'm sorry, I didn't mean to interrupt. Staff would like to know, does anyone have any questions for staff witness Christopher Lowe?
I see Ms. McLemore shaking her head.
I'm sorry, is that a yes?
If there aren't
No, okay,
any
I'm
from the
sorry.
town of Chestertown, it would be minimal, but I don't want to say absolutely not right now, but it would be minimal.
That's fine, thank you. Then he'll be ready. I just wanted to run that by. Thanks.
Thank you, sir.
Okay, Mr. Yeager or Mr. Drummond, questions for the staff witness?
Mine would likely be minimal.
Thank you.
I wouldn't have any questions.
Okay, thanks.
Can I inquire whether Mr. Sadinsky will be testifying?
I believe he will. Ms. McLemore?
I
Yes,
just
Your
didn't
Honor.
hear. I didn't hear PPRP in the list that the court asked about how long we would be.
No, I've already figured him into today and tomorrow. Okay. Mr. Albert, to keep you involved. Komar, you're familiar with the section on briefs?
Oh, yes.
And so the post-hearing brief is limited to, is it 50 or 60 pages?
I think it's 60. They talk about lithograph, and my understanding is that the shorter page cap is sort of an old archaic printing method that's no longer there. So my understanding it's 60 pages.
Okay, thank you. So I don't believe there's a need to go over 60 pages, but if anyone's going to request that, please be prepared to do so tomorrow. Okay, I know Mr. Hicks, I know you're up, but before we recommence the questions of Mr. Bauer, I did want to go back over some ground rules in hopes that we can, this can go smoothly today. Cell phones should be off or turned if necessary onto vibrate or silent. Let's act as though we're in a hearing room. Speaking objections, I think it would behoove the parties to keep those to a minimum. I don't think anyone helped themselves out yesterday with the speaking objections. A lot of times I know why you're objecting and I can rule. If I need the basis of your objection, I'll ask. So I think that'll help the other parties who might also want to object.
Your Honor, I'm sorry. What do you mean by speaking objection?
Okay, that's when you object to a question and you not only object, but you explain the basis of your objection while you're objecting.
So you're saying we should just say object and wait for a prompt from you if we get it in terms of explaining the basis for it?
That's preferable. I understand from my background that it's difficult for a lawyer to stop at objection because they want to say why they're objecting. So, you know, I'm a little bit lenient on it, but I'm just cautioning you that it's not necessarily helping your situation.
Thank you.
And due to the occurrences of misquoting or mischaracterizing testimony, I'm going to continue to ask counsel when they are going to quote someone's testimony to them, to a witness, and then ask a question, to please refer all of us to where in the written testimony they are referring. Also, a gentle reminder, I was not pleased at times yesterday with how witnesses were treated in this hearing. I let a lot of it go, but we were getting awful close to badgering. And the reason that's important is because that affects the record, because a witness who's badgered might wish to simply get off the stand and respond to a question in a way that is not accurate just to get off the stand. So witnesses are not to be badgered or harassed. That's not how witnesses are treated when they come in front of the commission. So I would appreciate just a little more respect being shown to witnesses. On to a slightly substantive item. I am sua sponte, revising a decision I made yesterday. Applicant Exhibit 12 was the joint motion to approve the settlement with the settlement attached. The settlement agreement comes in, but the joint motion itself is a pleading. I generally don't admit pleadings into the record because pleadings are not evidence, they're pleadings. The fact that the joint motion was filed in the docket is a fact that can be referred to, but as I said, the pleading itself doesn't come in, just the settlement agreement. Any questions, Mr. Bugelmans?
No, Your Honor.
Thank you. Okay. Now, Mr. Bauer is still under oath. Mr. Hicks.
Your Honor, I had just one housekeeping matter. I apologize. Very briefly, I don't anticipate his testimony coming up today, but Mayor Foster does have a conflict between 1:45 and 3:30 this afternoon. Because we did move through witnesses faster than I anticipated yesterday, I just wanted to put that on the record, just let Your Honor know. I advised him that likelihood before this week that the likelihood was him testifying on Wednesday because he was towards the end of the list, if not the end of the list, or Friday. But I just wanted to bring that to the court's attention before, unless we moved faster than I expected today.
Thank you. I think that what you've told him is accurate. Looks like probably tomorrow.
Thank you, Your Honor.
Are you ready to proceed then?
Yes, ma'am. And Mr. Bauer, are you there?
Yes.
Good morning, sir. How are you doing today?
Good.
I'm going to pick up. I don't think I have too many questions for you, but I'm going to refer to the ERD on page 19 of 45.
I have the page.
Thank you. So you note in that last paragraph that the town of Chestertown has designated the area a priority funding area, correct?
That's what I have here. Yes.
And you further state that it's a priority for future growth, correct?
Yes. We've got that information offline from the
Offline.
towns. From the town's information.
The information, are you referring to the comprehensive plan from 2015?
Yes, we looked up the planning information when we did this.
Okay. And so you would note from reviewing that this area is pretty much the only priority funding area for the town of Chestertown, correct?
That's what we learned. Yes.
Okay. Did you further read through the comprehensive plan in regards to why this area was the only priority funding area?
It's been a while, but one of the things I recall was they had the ability to provide water and sewer.
Okay.
That's one of the only things that I can remember. And it wasn't any detail because they had identified a number of areas where they thought they could get water and sewer. But like I said, I don't even know if the situation is status quo from them or not. I'm not up to speed on that.
Okay. I would say you're unsure then, but from your memory, it just had to do with. If I could finish the question, Your Honor.
Why don't you finish the question? I think he's just clarifying the response.
Because of the length of time, you would say you're unsure, but from your recollection, it had to do with water and sewer.
Yeah, I'm foggy on it, but yes.
Okay. Mr. Bugelman?
The witness answered the question.
Yeah, no,
Thank
the
you.
question's fine. I allowed it.
Thank you. I want to get to priority funding area. Are you familiar with what a priority funding area is?
Objection.
Okay, now I do need the basis. What's the objection?
This is outside the scope of Mr. Bauer's testimony. He does provide some basic information about zoning, but company witness Stevens is the zoning witness. He's the appropriate witness to ask.
Mr. Hicks, do you mind waiting and asking your questions of Mr. Stevens? If he's the more appropriate witness.
No, I have no problem with that.
Okay. Do you have another line of questioning?
If I could just collect my thoughts really quick. I don't think there's
Sure,
much
sure.
more.
Take your time.
No, I have nothing further, Your Honor.
Any redirect, Mr. Bugelmans?
I do, Your Honor.
The only thing I would say is yesterday, Mr. Yeager didn't get a chance to do cross-examination because I think he got disconnected when Your Honor requested his cross-examination and went to me. I don't know if that was
Okay,
any
thank
part
you.
of that.
Yeah, I appreciate that. I'll check in with Mr. Yeager. Did you have questions for this witness?
Your Honor, the questions that I had, the topics that I wanted to explore, Mr. Hicks adequately covered them. So if I were to ask questions now, they would just be cumulative. So I have nothing further for this witness. Thank you. But thank you also for checking in with me.
Okay, thank you. Mr. Bugelman, do you have redirect based on Mr. Hicks's questions?
Mr. Bauer, do you remember the questions yesterday related to decommissioning?
I think so.
Oh,
Yes.
I'm just going to interrupt and clarify. I'm sorry, you're correct. You have redirect with regard to testimony yesterday as well as today. I apologize.
I'm sorry, Your Honor. Thank you for that.
No, yeah, that's not you, that's me.
Okay, thank you. Okay, do you and your firm, Mr. Bauer, prepare these plans for solar projects regulated by the Maryland Commission?
We do prepare the decommissioning plans.
How many, approximately how many of these plans have you or your firm prepared?
At least 6, maybe 1 or 2 more.
Are these plans reviewed and processed and eventually approved by the commission?
Yes, they're reviewed and sometimes questioned and sometimes revised.
How would you describe the review process for these plans?
Well, the substance of the decommissioning plans are pretty much outlined based on historic actions by the Public Service Commission. So they've sort of evolved over the past 4 or 5 years. And since Melissa and I think work on, or H&B works on probably 80% of the projects that go before the Public Service Commission, we've closely followed the outline as it's evolved and as we've written them and as they've gotten approved over the years.
In your experience, have counties participated in these reviews, in the hearing or asking questions?
Yes, almost every county has their own requirement for a decommissioning plan. And in an attempt to be efficient about it, instead of having one for the state and one for the county, H&B has done everything that reasonable within our position as environmental contractor to try to get those plans to be as consistent as possible. Sometimes the decommissioning plans are co-signed and that the bonds cover both the state and the county.
Okay. Do you remember the questions yesterday about the disposal of waste upon decommissioning?
Vaguely. I
Are you
don't
able
remember
to-
the exact question. I remember we touched on the subject. Yeah.
Are you able to describe briefly for the plans that you've prepared in your experience, how is waste dealt with?
Well, it depends on what the material is. Some of it may go like concrete may simply be identified as rubble, and that is usually disposed of in an approved county landfill or rubble fill. Most of the metals are gathered up and they're sold on the market. The panels are typically recycled. So you're either taking it to an approved disposal facility that's licensed by the county or the state, or you're selling it to somebody who's reusing the product. And the panels, there's a new market for recycling panels. So it's usually one of those three categories.
In your experience, has the commission or PPRP ever raised concerns about environmental contamination that would occur during operations or that would remain after decommissioning?
During operations, we have had some questions about, generation facilities or substations, or inverters if they use oil. And in most cases, the Public Service Commission has added a condition that they have to have an oil protection plan during the operation of the system. And those would be the few things that during decommissioning, the contractor would be advised as to the concern of any spilling of the oil. But that's about the only major thing that comes up as far as waste or hazardous material.
Okay. And under PPRP's conditions, can a developer construct a project the commission has not approved a decommissioning plan?
No, they cannot.
Do you remember the questions about impacts to soil quality at the site from yesterday?
Yes.
Are you familiar with the depth of the water table at this site?
Yes. I think I testified that our role is to coordinate all the technical assessments and evaluations, which includes the design and the environmental assessment. So we advised the contractor that despite the fact that we had done NRCS soils evaluations ourselves online, and we had actually produced the maps in the back of the ERD and the appendix that show the prime farmland, that those maps typically, I won't say typically, often are not exact any more than the wetlands are exact or the FEMA are exact. They're within a reasonable parameter of effectiveness. So we asked them to do a geotechnical report.
Mr. Bauer, I'm
Please
sorry.
stop.
There's an objection. Was it Mr. Drummond?
It's not responsive.
Okay, Mr. Bugelmans, maybe you could reword or rephrase your question and see if we can get a responsive answer.
Sure. Are you able to? Are you able to just?
Water
I'm sorry, Mr.
table.
Drummond. I wasn't able to hear that, but I'll continue. One final question: are you able to describe the depth of the water table at this site?
The geotechnical report said that the average depth was about 15 feet.
Okay, I have no further questions. Thank you.
Mr. Bauer, you sponsored section 1 of the ERD, correct?
Yes.
Okay. I'm on page 4 of 45 at the very bottom. Prior to connecting to the DPL system/grid, the power generated by the project will tie into a new on-site substation. By on-site substation, do you mean a substation that's within the project limits?
Yes. In order to have the power be able to be consolidated on site before the interconnection, there's usually an on-site substation.
And that would be on the north side of Morgnec Road?
On the north side of the road, yes.
Okay. That sentence goes on to say, that the new on-site substation will be connected to the Chestertown substation. So on the very first page of the ERD, is the X in the photograph meant to show the location of the Chestertown substation?
Yes, yes, Your Honor.
Okay, and am I correct that the Chestertown substation is located within the boundary of Chestertown?
That I don't recall.
Is there a witness that can recall that? Mr. Bugelmans?
Trying to think here. I think either Mr. Clark or Mr. Stevens could know the answer just based off of the scope of their testimony, but I can't tell you for sure without having them on the stand and having them respond.
Okay, well, we can go about it a couple different ways. I can take judicial notice of Google Maps, which I pulled up, and show the Chestertown substation. And pretty clearly within that yellow line back on, well, it shows up on the cover page of the ERD, but then also, if you go to, thought there's a better map. No, the best map, I guess it looks pretty much the same as on page 7 of 45. If you see the yellow line to the right of the X, I believe that's the boundary of Chestertown, which would reflect that the substation is within the town of Chestertown. And I certainly don't want to have a legal discussion with Mr. Bauer or any other witness. I want to have it with you, Mr. Bigelmans, with regard to 7207E. So let's do that now, and then we can get to the right witness for additional
Okay.
facts if we need to.
Okay, Your Honor. I'm pulling it up on my screen here now.
So the wording is slightly different. Are you there?
I'm not, Your Honor. Just
Okay,
one
let me
minute.
know when, I'm sorry, let me know when you are.
Okay. Almost there. Okay, I'm there, Your Honor.
Okay. So in E4, the wording is the efforts to resolve any issues presented by a county or municipal corporation where any portion of the generating station is proposed to be located. So I believe from what I've read in testimony that the generating station is completely within Kent County outside of the border of Chestertown. And that's what
correct, Your Honor.
that's what I'm looking to confirm from your witnesses. But if you scroll up to E1, what the commission must give due consideration of is the recommendation of the governing body of each county or municipal corporation in which any portion of the construction of the generating station is proposed to be located. And just based on my common knowledge, I believe if we go back to Mr. Bauer's testimony, the applicant has proposed to obtain easements from neighboring property owners along the route of the GenTie. The GenTie is what's going to tie the on-site substation into the Chestertown substation. Pretty sure that that construction will necessarily then be within the town of Chestertown. Am I correct? Is that Mr. Bauer? Would you like
Are
to
you
answer?
asking me or?
Well, this is where I don't want to get into a legal discussion with you. So
Yeah.
I'm
Okay.
trying to be sensitive to, I need this information in order to properly interpret the statute. I'm looking for Mr. Bugelman's guidance as to the legal aspect, and then when I can turn to you for the factual information.
I do view, Your Honor, in terms of where on the ground things will physically go, I view that more as a factual matter. I understand the concern, and obviously with respect to the statute, I can answer those questions, but with respect to where things are going to be located and where that relates to the actual boundary of the town, I think that is respectfully more appropriate for a witness to answer.
Okay, well, just answer this. Does the applicant take a position that any portion of the construction is not located within the town of Chestertown?
Again, I see the point.
If you're not taking a position either way and you need me to ask your witnesses, that's fine. I just wondered if you were taking a position. If, in other words,
Yeah,
we could simplify this if you were going to stipulate that it's within the town. Do you understand? But if you're not going to so stipulate, then I'll turn to Mr. Bauer and then Mr. Clark.
I can't stipulate to that. I mean, I could tell you our position with respect to what is actually part of a generating station that's under the commission's jurisdiction. I could speak to that, but I'm unable to stipulate because unfortunately, I just don't know on what side of the line any part of the facility will fall. Unfortunately, I think a witness has to answer that question.
Okay. Though I am interested in what you just said about what constitutes construction of the generating station, to the extent that you are going to argue that the gen-tie is not part of construction of the generating station.
Sure. So so the definition of a generating station under the commission's regulations is the integral plant for the generation of electricity. The way that has generally been interpreted, at least by PPRP with respect to its conditions, is both the actual project and then any kind of lead line to the point of interconnection. So if the point of interconnection is on the Chestertown substation, I think based off the commission's precedent and the way that these have been reviewed, I think that is within the jurisdiction of the commission to consider within the context of the CPCN.
Okay. Are you finished? I'm sorry.
I am finished, Your Honor.
And then Mr. Bauer is not the person to speak to whether the point of interconnection is definitively at the Chestertown substation. That would be Mr. Clark.
Actually, I can tell you that we evaluated 2 different locations, which may figure into you getting the correct answer. If you want me to explain the
yes, please.
So on the north side,
excuse me, if I could just ask for clarification, Mr. Bauer, evaluation of 2 sites for what specifically?
for the interconnection.
Okay.
We worked with the State Highway Administration, my firm did, and using exhibits that were prepared by the consultant, who was Davis, Bowen, and Friedel. They evaluated 2 alternatives for the applicant. One was to keep the gen-tie on the same side of the road and obtain rights of way, and then do a 90-degree crossing of Morgnec Road right in front of the Chestertown substation. We did get conceptual approval, by the way, from the State Highway Administration to be able to do that. The applicant is not qualified to obtain the permit. It has to be the utility, a licensed utility company in Maryland. The other alternative that we looked at was crossing the road right at the project boundary. So that would be it would be the southwest corner of the project, and crossing the road immediately, crossing Morgnec Road right at the corner of the property, and then obtaining the right of way on the other side of the road, on the south side of Morgnec, and then moving in the westerly direction and interconnecting to this Chester substation that way. So we right now we have 2 alternative gen-tie designs, and I don't know that a final decision has been made on either one.
Okay, but both alternatives would tie in and the interconnect would be at the Chestertown substation on the south side of the road, correct?
Yeah. Yes, Your Honor.
And I read that the proposal is to go underground.
It would be directionally drilled, either option.
Okay. So I don't
And
see
it-
a scenario under which you don't end up in
Yeah.
within the town of Chestertown's boundary.
Your Honor,
Uh,
I'm sorry. I don't mean to interrupt. I mean, I'm, to be frank, I'm kind of frantically looking at the town's website and various zoning maps. And what I'm seeing here is that, at least on the maps I'm looking at, the substation is not located within the town boundary. I haven't been able to verify that. But I do view this as, it is a factual matter. And where the substation is something that's easily ascertained as long as we have something that we agree is the official map. And based off what I'm looking at, I don't believe Google is necessarily accurate. I have reason to believe it's not. So one way we could handle this is simply a bench data request, I think even to the town or the county, because I think they have access to the official maps. And then once we get that, I think it puts the issue to rest. I just wanted to point that out. I didn't mean to interrupt your questioning, but I'm kind of looking through these maps here, and that's what I'm seeing.
Okay. I will accept that your belief that Google Maps is not accurate. I don't know if the zoning map is the best source of the information either. I do agree with you, though, that the town probably has this information. Maybe their witness will provide it. If not, yes, I can do a bench data request. Okay, I think that is all I have for Mr. Bauer. Thank you, Mr. Bauer. Any questions based on my questions?
No. Oh, sorry.
I have no questions, Your Honor.
Any other council have questions for Mr. Bauer based on my questions? Okay, hearing none.
I didn't know. I'm sorry, Your Honor, I forgot. I thought I unmuted myself. I was just speaking to my computer by myself. Just really quickly for Mr. Bauer, you referenced the two designs for these subsections, or excuse me, the interconnections to the substation.
Yes, sir.
Do we have these as an exhibit to the ERD?
I don't know that they were available when we did the ERD. I believe these designs were in more recent times.
Okay. That's all I have, Your Honor.
Okay. Anything else? All right, thank you, Mr. Bauer, for your testimony. You're excused.
Thank you, Your Honor.
Mr. Bugelmans, your next witness.
Thank you, Your Honor. As our next witness, we will call Mr. Frank Depew. Mr. Depew, if you're, yeah, I see you there. If you could turn your video on, please.
Mr. Depew, can you please raise your right hand? Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Mr. Bugelman's attestation, please.
Yes, Your Honor. You think I'd have this memorized by now. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you. Please proceed.
Thank you, Your Honor. Mr. Depew, can you please state your full name and provide your business address?
Edward Franklin Depew, 337 Log Canoe.
You're gonna have to speak up. It's too loud. Get closer to the computer.
Mr. Court Reporter, should he repeat his answer?
Yes, I could not hear it.
All right, is this better?
Much.
Okay, if not, I can put on headphones. Edward Franklin Depew.
Could we try the headphones?
Okay. Give me a moment, thank you.
Quite all right. Thank you for taking the time to do it. Sorry, Your Honor.
I'm now connected via my headphones. Is this better?
That's wonderful. Thank you very much.
Thank you. Sorry for the inconvenience.
Okay, so let's just start from the beginning, Mr. Depew. Can you please state your full name and provide your business address?
Edward Franklin Depew, 337 Log Canoe Circle, Stevensville, Maryland, 21666.
What is your company and title?
The company name is Urban Grid Solar Projects, LLC. My title is Chief Executive Officer.
Thank you. Do you have before you a document entitled Direct Testimony of Frank Depew, dated August 2nd, 2019, consisting of 10 pages?
I do.
Your Honor, I would like to request this document be marked for identification as applicant exhibit 27.
So marked.
Thank you, Your Honor. Mr. Depew, was this document prepared by you or under your supervision and control?
Yes, it was.
Thank you. If I were to ask you the same questions today, would your answers be the same?
They would.
And is your testimony true and correct to the best of your ability?
Yes.
Thank you, Mr. Depew. With that, Your Honor, I'd request that we move applicant exhibit 27 into evidence.
Any objections? Hearing none, applicant exhibit 27 is moved into the record.
Thank you, Your Honor. The witness is now available for cross-examination.
Do we need the attestation? That I'm in the room alone with no one else? Okay.
I think I already did that, Mr. Depew, so.
Okay. All right. Sorry, I missed that.
Okay, attorney for KCPA.
Mr. Depew, my name's Chris Drummond. I represent Kent Conservation and Preservation Alliance. Mr. Depew, I'm going to do my very best to follow the judge's request that we refer directly to testimony. On page 4, lines 17 and 18.
Yes, sir.
Ascribed to Ms. Morgnec a statement that her job was to protect the zoning laws of Kent County and that it was her intent to protect those laws. Do you see that statement?
That's not exactly what it says. I'll be happy to read it to you.
I added the word Kent.
Right. So,
and I added the word she.
Essentially, it was her job to protect the zoning laws of the county, obviously as they were written at that time. I agree with that.
Right. Are you criticizing Ms. Morgnec for doing her job?
I'm going to break in here. I'm sorry. The sentence I'm reading says, according to Ms. Morgnec, the county has a job to protect the zoning laws of the county, which was its intent here, meaning the county. So I'm confused. Can you ask your question again?
Morgnec tell you that it was the county intent to protect its zoning laws?
Yes.
Okay. And are you critical of Ms. Morgnec's efforts? Excuse me, Your Honor, the county's efforts to protect its zoning laws?
No, I'm not.
Zoning text amendment that you commissioned Mr. Stevens to draft would have had the effect of allowing utility scale solar in Kent County as a conditional use or special exception. Is that correct?
Yes, that's correct.
And that would not have been an amendment allowing only the project that you seek to have approved. Is that right?
I believe that Mr. Stevens will get into this more, but we drafted a very targeted text amendment to protect the county from leaving things wide open for solar. And as you'll hear,
That wasn't my question, Mr. Your Honor. I don't want to be accused of harassing this witness, but I would like him to answer my questions.
Okay, why don't you restate your question?
The zoning text amendment that you commissioned Mr. Stevens to draft and present to the county would not have been limited, would have allowed utility scale solar as a conditional use or special exception on properties other than the property you seek to have approved for this solar development. Is that correct?
had those other properties met the requirements of this zoning text amendment, yes, that's correct.
How many such properties across the county would have become open to utility scale solar by conditional use or special exception had the amendment drafted by Mr. Stevens been adopted by the county commissioners?
Objection.
Do you think it's outside the scope of this witness's knowledge?
It is, Your Honor. This is within the scope of Mr. Stevens' testimony. He discusses the actual content of the text amendment. Mr. Depew is here to talk about the general efforts to address the concerns of the county.
If I might, that's exactly my point, in that Mr. Depew, in relatively blunt terms, in his testimony, suggests that the county was uncooperative, and I'm exploring the basis upon which the county may not have done exactly what he wished it to do.
You're far afield of that, I think, Mr. Drummond. Can you point me to where in your testimony you just referred about his blunt testimony with regard to the county?
I can't.
You can't do that?
I guess I'm struggling. I am struggling with this. I guess I've been in court too much, and the concept of cross-examination in a court setting versus this one. So I guess I'll withdraw the question.
Well, it sounds as though there's a witness that's more appropriate for your question.
Mr. Drummond, if you could lean in closer to your computer, because every so often you fade out and I'm having trouble picking you up a little bit. Thank you very much.
Thank you.
Okay, so perhaps you can ask your questions of Mr. Stevens, and this witness, according to his testimony, the purpose of his testimony is to describe Urban Grid's development efforts for the Morgnec Road Solar Project with a focus on efforts to address issues raised by Kent County and Chestertown.
Mr. Depew, on page 8, lines 12 and 13, you say the following. I'm sorry, I know I'm going to fade here, so let me bring this a little closer. I would submit that this demonstrates an interest in all counties playing a role in meeting these aggressive targets. And the "this" mention that is in that sentence refers to changes in state law. Is that right, Mr. Depew?
It references the overall target for renewable penetration, particularly solar projects in the state of Virginia.
Maryland, but
Maryland, sorry.
to what extent all counties in Maryland have played a role in meeting these aggressive targets?
I do not.
Advocate that all counties should play a role in meeting these aggressive targets?
I'm sorry, I didn't hear the question portion of that question. I only heard the statement portion. Can you repeat it?
Advocate. I said, do you advocate that all counties should play a role in these aggressive targets?
I believe so.
Corollary, also something that you would advocate.
I couldn't understand you.
I haven't finished the question yet, Mr.
No, I
Depew.
couldn't understand the first word you said.
Corollary, then, also true that no one county should take a disproportionate role in meeting these aggressive tactics, aggressive targets, excuse me.
My opinion is that one county shouldn't decide that no solar is going to go into that county no matter what.
Okay.
On a
And,
large scale. That's my opinion, and I'm going to finish my answer if I'm allowed to. And that and that other, that counties that can participate should participate to a reasonable extent.
And every county, therefore, should participate in the approval of a solar facility at 45 megawatts in a district where it's not permitted?
I really don't know what you're asking.
Your position that Kent County does not offer land for the development of solar projects, Mr. Depew, or simply doesn't offer land for a solar project that you wish to have approved?
My opinion is, and it will be covered later in additional testimony, particularly from Adam Thompson, who did a lot of siting work in finding this site, as well as a significant research into other sites that might be available. And I believe that testimony will be presented by, by Kevin Clark of Urban Grid, is that I'm sorry, repeat the question.
Asked you whether Kent County prohibits solar utility scale. I think I said, does it offer land for utility scale solar, or does it only prohibit that which you wish to have approved? That's not exactly what I asked, but it was a sense of it.
Okay, thank you for reminding me where I was going. So essentially, the land that they did essentially set aside for solar was not cited so that a utility scale solar project of any reasonable size could be built in the county. And a 45 megawatt solar array is not a very large utility scale project.
Mr. Depew, do you take up then Mr. Thompson's definition of utility scale solar as only that which generates 20 megawatts or more?
Objection. Outside the scope of Mr. Depew's testimony, I let it happen a little bit. He's the CEO of the company, but these are questions that are best directed for Mr. Clark, who has adopted that the testimony that's being questioned by Mr.
Okay.
You just said that
Can I please? I'm reading from page 8, right after the portion that Mr. Drummond referenced. However, as demonstrated in applicant Thompson's direct testimony, Kent County's current zoning ordinance if not preempted by state law, would impose an effective ban on all utility-scale solar projects, pushing development to its surrounding counties. So I think Mr. Drummond's questions are close to that, Mr. Bugelman, so I'll allow him a few more. I understand there's better witnesses, but
Okay.
okay, thank you.
Okay, Mr. Depew. The question was whether you adopt Mr. Thompson's definition of utility scale solar as only those facilities that generate 20 megawatts or more.
Yes, I do.
Notwithstanding the fact that Urban Grid has been involved in a number of solar projects that it's either gotten approved or has constructed that generate less than 20 megawatts.
Those were all what are called distributed generation solar projects, and they're connected behind the meter. They're not utility scale solar projects, which are connected to the transmission grid.
Be satisfied to do those in other counties. Why don't you propose one in Kent County where there's room for them?
We already own one in Kent County, and we sell the power to Kent County, and it's on Kent County land at Fairleigh Lagoons.
You that's all the questions I have. Thank you.
Mr. Yeager, do you have any questions for this witness?
I do not, thank you.
Mr. Hicks, do you have any questions?
Briefly, thank you, Your Honor. Good morning, Mr. Depew. How are you doing?
Good morning, Mr. Hicks.
My name is Jesse Hicks. I'm with the town of Chestertown. On page 5, question 11 of your direct testimony.
Question 11 or line 11?
Line 11.
Thank you.
Do you see where I'm referring to?
Yes, I do.
Okay. You indicate that you and Adam Thompson met with the Chestertown, at the time, the Chestertown Mayor, Christopher Serino, on March 9th, 2017, correct?
That's correct.
You would agree with me that it was a positive meeting?
Yes, it was a positive meeting. It was an opportunity to just talk to him about the project and what we were hoping to do.
And essentially told you that although it did not fit with the Chestertown Comprehensive Plan, the town would be open to some type of solar farm in the area.
Well, it seemed like this was now 5 years ago, so forgive me, but he was very cordial. He was quite nice, and he we talked a little bit about the bypass, about the annexation, and at the time he didn't seem to be terribly bothered about it, but he didn't make any commitments whatsoever. And after we met with him, I don't believe we were ever able to arrange another meeting with him.
Right. I'll get to that in 1 second. And I'm only going off of your direct testimony. So I'm looking at lines 16 and 17 that says he, referring to Mayor Serino, indicated he believed there is a path forward based on our proposal to include a public park facility and substantial vegetative screening.
Right. That's my testimony, and that's about all that I believe I can say about that.
Okay, that's fair. And then you noted in the next page, I believe page 6, line 2, that you received an email from Mayor Chris Serino on May 19, 2017, basically saying he opposed it. And based on your testimony, he opposed it because it was not permitted by the county's zoning ordinance.
That's correct. That's correct.
You just indicated that you were never able to have another meeting with Mayor Chris Serino. Were you ever able to have another meeting with any representative from the town of Chestertown?
Not that I'm aware of.
Okay, and you don't indicate, and I'm just going to, because it's cross, you don't indicate in your direct testimony that Urban Grid ever reached out to the town of Chestertown to reinitiate any conversation.
I can tell you that we did. We reached out to the mayor a number of times, and he didn't return our calls.
That just no return of phone calls.
Correct.
Do you recall when those phone calls were made?
They were made by Adam Thompson, and that may or may not be in his testimony.
Okay. Do you have any idea, and again, this could be Adam Thompson's testimony, do you recall how many phone calls were made?
I know it was more than one. I mean, we were very much, trying to come up with a solution that would be palatable for everybody, including investing in amenities and things like that. But I don't know how many times he called and was rejected. It may have also been emails. But you're asking me for conjecture, and I'm not really willing to.
That's fair. If that's your answer, that's your answer. I accept that you would say Adam Thompson would know better. How many solar farms has Urban Grid constructed?
We don't construct them. So let's start there. We develop them, and we hire somebody to construct them, or we sell the project and somebody constructs them. We've currently 30.
Stop you there really quick. And develop, construct. I apologize for the vocabulary. You said you develop them and then sell them. Why would you sell them prior to constructing them?
We don't always, but we have sold them to utilities in the past. So we have 32, to more directly answer your question, I believe we have 32 projects that have been developed and constructed by an EPC for us that an affiliate still owns those projects. Those are all distributed generation projects, such as the one that we built at Fairleigh Lagoons in Kent County. We have 4 other projects that have been constructed and are in service. All 4 of those projects are in the state of Virginia. One of those projects is 150 megawatts AC, and another one is 98 megawatts AC. And we did another one that's 20 megawatts AC, and a third one that is, I believe, 17 megawatts AC.
Mr. Hicks, I believe you asked him why they would sell it before construction. Did you get an answer to that question?
I did not.
Did you understand that question, Mr. Depew?
Yes.
Can you answer that question, please?
Yes. You can't develop and own all the projects. There's a tremendous amount of capital that's required to build and own a solar facility. And quite frankly, we're not in a position to own all of the facilities or 100% of all the facilities that we're going to develop. That may very well change, but currently, that's where our company is at. We're predominantly a developer of these solar projects, and we intend to keep an ownership stake in them moving forward.
You intend to? I believe you said currently you have 32 in operation?
Objection.
Pretty sure he opened the door to Mr. Bugelmans.
Well, I think, respectfully, Mr. Depew's answer proved the point of the objection, which is this is irrelevant to the commission's consideration of the project. This is completely unrelated to any of the 2-207E factors. So I don't know where this is going.
I'm not sure either, but I'll give Mr.
Okay.
Hicks a little leeway.
Okay.
Thank you, Aaron. And so just a couple more questions. I believe you said you have 32 in operation.
Correct.
Okay, and could you just tell me how many you have developed through Urban Grid?
How many we've developed that are in service is 36 projects, 32 of which we have an ownership interest in.
So safe to say 4 of those you sold your ownership interest in.
That is correct.
That's all I have for that.
Thank you.
I have nothing further there.
Any redirect, Mr. Bugelmans?
I have no questions, Your Honor. No redirect.
Okay. Thank you, Mr. Depew. You're excused.
Thank you.
This is mostly for my housekeeping. In the event that I failed to do so, clearly on the record, applicants exhibits 24, 25, and 26, which were testimony of Dane Bauer, were admitted into the record. Just wanted to make that clear. Mr. Bugelmans, your next witness.
Thank you, Your Honor. Next up, we will call Mr. Kevin Clark. I see him up on the screen, Your Honor.
Yes, I do as well. Mr. Clark, could you please raise your right hand? Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay. Mr. Bugelmans, do you have an attestation?
Yes, I do, Your Honor. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you. Please proceed.
Thank you, Your Honor. Mr. Clark, can you please state your name and provide your business address?
Kevin L. Clark. My business address is 337 Log Canoe Circle, Stevensville, Maryland, 21666.
Thank you. And what is your company entitled?
Urban Grid Solar Projects, LLC.
What's your title?
Project Manager.
Thank you, Mr. Clark. Do you have before you a document entitled Direct Testimony of Kevin Clark, dated August 2nd, 2019, consisting of 7 pages inclusive of attachments?
I do.
Thank you. Your Honor, I would request that this document be marked for identification as applicant exhibit 28.
So marked.
Thank you, Your Honor. Mr. Clark, do you also have before you a document entitled Direct Testimony of Adam Thompson, dated August 2nd, 2019, consisting of 13 pages?
I do.
Your Honor, I would request that this document be marked applicant exhibit 29.
So marked.
Thank you, Your Honor. Mr. Clark, do you also have before you a document entitled Supplemental Direct Testimony of Kevin Clark, dated August 20th, 2021, consisting of 10 pages?
I do.
Thank you. Your Honor, I would like to request this document be marked for identification as applicant exhibit 30.
So marked.
Thank you, Your Honor. And then finally, Mr. Clark, do you have before you a document entitled Supplemental Rebuttal Testimony of Kevin Clark, dated October 29th, 2021, consisting of 5 pages?
I do.
Thank you, Mr. Clark. Your Honor, I would respectfully request this document be marked as applicant exhibit 31.
So marked.
Thank you. Mr. Clark, was your direct testimony, supplemental direct testimony, and supplemental rebuttal testimony prepared by you or under your supervision and control?
Yes, it was.
And with respect to Mr. Thompson's testimony, is it correct that you are adopting this testimony as your own?
I am adopting this testimony with changes.
Could you please describe those changes?
Action.
I think we need to hear the changes first.
That's correct. We need to hear how the testimony is being modified before entertaining objections.
If I might.
No, we're going to hear the basis of the changes, and then we'll talk about whether those changes are acceptable or not.
Okay.
Shall I continue?
Yes, it is.
There are two changes. The first being on page 1. I would like to replace lines 1 through 14 with my background and experience that was submitted in my direct testimony submitted August 2nd, 2019.
Okay, Mr. Bugelman, I don't think that's necessary. In my experience, when a witness adopts someone else's testimony, it's understood that they're not saying those things that the former witness said with regard to their name and experience.
I think that's true, Your Honor. I've also seen it done where, I've seen like red lines where, that's been changed. As long as it's clear for the record that, Mr. Clark is adopting this testimony and it's understood, obviously it's on Mr. Thompson, I think it's fine.
I think it's clear, in particular because Mr. Clark has filed direct, and so we have his name, title, and experience in his direct testimony. So I think we're fine.
Okay.
What was the other change?
The second change would be on page 10, and it is line 12. I would like to change that answer to no, I did not. I was not involved in citing the Morgnec property. Morgnec.
Okay. I mean, Mr. Bigwins, I understand, I think what this is that Mr. Thompson answered yes to this. So instead of changing it, why don't we just strike lines 10 through 12? Does that work for you?
That's fine, Your Honor.
Okay. And that might take care of Mr. Drummond's objection. I don't know.
Okay.
But I'm striking that. Okay. Were those the only changes, Mr. Clark?
Yes, Your Honor.
Okay. Now, Mr. Drummond, I will hear from you. I'm sorry. Mr. Drummond. Mr. Hicks, are you trying to also object?
I'll wait until he offers it and offers the document into evidence, I guess.
Okay, Mr. Hicks, were you objecting?
I have a question. Yes, it would be an objection. Because we're striking 10 through 12, did you assist in the selection of the proposed site of the Morgnec Road solar project? The next question being, please describe the process by which Urban Grid selected the proposed site. If he didn't assist in the selection, I don't believe that he can then answer the process by which Urban Grid selected the proposed site.
Mr. Clark, do you have personal knowledge of the process by which Urban Grid selected the proposed site?
I have personal knowledge of the typical method used for Urban Grid to select sites.
So you're familiar with this answer then?
Yes,
the process. Okay. Okay, what about the last, starting on line 21? Do you have personal knowledge of that?
Yes, I do, Your Honor.
Okay. I'm fine, Mr. Hicks.
Thank you, Your Honor.
Okay. Mr. Drummond. Well, okay, I'll go back to Mr. Bugelmans. Mr. Bugelmans, are you moving exhibits 28, 29, 30, and 31 into evidence at this time?
I will, Your Honor. I just have a couple additional questions before we get there.
In the nature of voir dire or?
Yes, I think it's relevant to, if I could proceed, I think you'll understand the relevance.
Okay, please.
Wait a minute. I object to that. I don't think you voir dire your own witnesses to.
I'm not.
Your Honor.
Mr. Drummond, hang on.
Let me ask.
Yes. Mr. Drummond, Mr. Bugelmans is going to answer the question. And he said, I'll understand from his question why he thinks he needs to ask the question. So let's give him a chance to ask the question and then I'll make a decision. Okay.
Okay. Mr. Clark, have you rerun Mr. Thompson's analysis?
Yes, I have.
Do you agree with his conclusions?
Yes, I do.
Thank you.
Your Honor.
Can you speak up, Mr. Clark? You're just too soft.
Hey, let's see if I can make that better. Sorry about that.
Okay.
Just
Those
lean in.
questions, those questions go directly to whether he can properly adopt Mr. Thompson's testimony. So they're acceptable. And now, are you moving them into evidence now, Mr. Bugelmans?
Yes, Your Honor. I mean, for the record, I should probably ask, the standard questions before I do that, just to make
Oh,
sure.
I thought you already did. I'm sorry.
I haven't, Your Honor. I'm sorry. But Mr. Clark, with respect to all 4 documents, if we're to ask you the same questions today, would your answers be the same?
Yes, they would.
Is the testimony contained in all 4 documents true and correct to the best of your ability?
Yes, it is.
Thank you, Mr. Clark. And Your Honor, with that, I would request to move applicants exhibits 28, 29, 30, and 31 into evidence.
Mr. Drummond, did you note an objection for the record?
Yes, I did.
Okay,
And-
what's the basis of your objection?
Your Honor, just before he gets into the time, Chestertown notes an objection as well.
Thank you.
And for the. and-
Object to Mr.
I would object.
Hang on, I'm sorry. Mr. Yeager's a little slower on the mute button.
Yeah, sorry. I would object as well for the record.
I might
Okay.
point out, Judge. I might point out, Judge, that it looks like a number of us are having connection problems. So right now, everything seems okay. I think somewhere in all of this, we're all fading in and out. Anyway,
Okay.
I don't object to Mr. Clark's.
Hold up. Mr. Court Reporter, am I fading out?
No, but Mr. Drummond is.
Okay, Mr. Drummond, why don't you turn off your camera? As I said, that sometimes helps with bandwidth issues. And then you can proceed.
Not object to the introduction of Mr. Clark's testimony. I object to the introduction of Mr. Thompson's testimony. Appears to me that I'm swimming against a fairly swift current, however, but let me at least lay the basis. It seems to me it would not have been difficult in the least for Mr. Bugelmans to do what any attorney would do in a civil or even a criminal action when a witness is no longer employed by a party to the case, and that is to subpoena the witness if he or she will not participate voluntarily, or to otherwise secure that individual's testimony by way of video deposition.
Okay, Mr. Drummond.
In-
Mr. Drummond, I'm going to stop you right there and address that point. It's fairly common in the commission's practice for this type of situation to occur. We don't generally subpoena witnesses like in a criminal proceeding. Rather, if it's a change of employment situation, it's common for one witness to adopt testimony of the other so long as they are able to do so. Do you have another point?
That's why I began my remarks by saying I detect I'm swimming against a very
Mr. Drummond, Mr. Drummond, if your lack of familiarity with commission procedure is what you describe as a strong current against you, I'm sorry that you're not familiar with commission procedure and policy and practice, but that's on you. Okay? Can we skip those type of derogatory comments, please?
Not derogatory.
Whatever they are, they need to stop. Okay? Do you have another basis for objecting to this testimony coming into evidence?
Yes, I object to the introduction of testimony that is premised that is the work of someone else who is not available for cross-examination.
Okay, Mr. Clark's available for cross-examination. Your objection is overruled. Mr. Hicks.
Thank you, Your Honor. Similarly, My objection is based upon cross-examination, noting your ruling. If during cross-examination, if something comes up, I would just renew my objection.
Okay. And as we did with witnesses yesterday, we'll move forward with cross-examination. If we get to a point in cross-examination where I determine that this witness cannot answer questions that are related to the testimony that he is adopting, then perhaps the document won't come into evidence, but I'm not going to deny it outright. Do you understand? Anything else, Mr. Hicks?
No, ma'am.
Mr. Yeager?
I adopt the same positions of Mr. Drummond and Mr. Hicks, and I'll just leave it at that. I don't want to run the risk of upsetting Your Honor, which I'm sure I will if I continue.
Not necessary to upset me, Mr. Yeager. You will also be given an opportunity to question the witness. And as I said to Mr. Hicks, if we reach a point where I determine that this testimony shouldn't be adopted based on the answers to that cross-examination, then I'll make a decision at that time about whether the exhibit comes into evidence. Okay. Mr. Drummond, do you care to cross-examine the witness at this time?
Yes, thank you. Mr. Clark, as you know, I'm Chris Drummond. We haven't seen each other in a long time. It's nice to see you.
Wonderful to see you, Chris. Mr. Drummond, sorry.
That's okay. Mr. Clark, how many acres of solar panels are located in the critical area resource conservation area?
Where? Resource conservation area where?
On the property?
0. Under the current design, there are 0.
Are you familiar with the new critical area maps that have been adopted by Kent County?
Yes, I am.
And in response to a data request, Morgnec Road Solar LLC indicated that when the maps were anticipated to be adopted, there were approximately 16 acres expected to be within the new resource conservation area as GIS mapped by Kent County.
Okay. I'm aware of that.
All right. And are the new maps consistent with the expectation that there would be 16 acres of solar panels within the expanded critical area?
That is not correct. We have altered our design and we actually lost 15 acres by engineering design.
All right. And has anyone seen that revised plan?
Anyone being who?
Other than Morgnec Road Solar, its employees, perhaps its lawyers?
Yes. I believe it has been submitted as a supplemental design to the Public Service Commission.
Could you direct my attention to when that occurred and where?
No, I cannot.
So it's your testimony, if I correctly understand it, that 15 acres of solar panels have been removed from the plan set forth in the ERD.
What I will confirm is that 15 acres of production area have been lost due to the critical area expansion. I can't guarantee that we have lost 15 acres of solar panels.
That answer to me, please.
A portion, I don't have the design in front of me, a portion of the critical area that was encroached may not have had solar panels on it. I can't confirm that we have lost exactly 15 acres of solar panels. I can confirm that we have lost 15 acres of production area.
Well, do you know how many acres of solar panels are now within the new RCA, the
On our
expanded RCA?
on the Morgnec solar project, there are 0.
Yes. And that's bear with me,
Most
and
definitely.
that is displayed on a plan that you believe has been submitted to the Public Service Commission.
I believe so. I cannot confirm that with 0 doubt, but I believe it was submitted to the Public Service Commission.
You're the project manager, Mr. Clark,
I am, yes.
and wouldn't you know if that revised plan had been submitted to the Public Service Commission?
I am fairly certain that it was. I just can't give you the date.
And would that plan have been distributed to PPRP as well?
I would assume it would have been, yes.
Does the plan show the solar panels that have been removed from the expanded RCA going elsewhere on the property?
It does not. What it does show, it shows the new critical area boundary and the old critical area boundary.
If someone could direct my attention to that document and where it is in the record, perhaps Mr. Bugelman's, I'd be happy to pull it up.
I'm permitted to answer, Your Honor.
Yes.
I would refer Mr. Drummond to PPRP's project assessment report. I believe the site plan that Mr. Clark is referring to was provided in response to a PPRP data request. And I would also point counsel to PPRP condition 15, which deals with the critical area issue.
Thank you.
Lawrence, all those documents to which he referred were submitted before Kent County adopted the new GIS critical area map.
I'm sorry, I missed the first couple words, Chris. Mr. Drummond, could you do that again?
I said the documents to which Mr. Bugelman's referred were submitted before Kent County adopted the new GIS critical area maps.
Did you ask the witness when Kent County adopted the new critical area maps? Because I don't know that date, Mr. Drummond.
No, Mr. Clark.
I don't know the date that it was adopted by Kent County. What I do know is that we were given the new boundary before it was adopted and preemptively moved our critical area boundary, assuming it was going to be adopted at some point.
Judge Lawrence, I can tell you the new maps were adopted in April of 2021.
Okay, he just said that they were given the boundary before they were adopted. I'm not sure. It sounds like you need to refer to some documents.
I'm trying to refer to a document that I don't think I've ever seen.
Well, why don't you start with the ones that you have that the witness referred to?
Your Honor, I apologize.
Sorry, that Mr. Bugelman's referred to, I guess.
Your Honor, I don't mean to interrupt during Mr. Drummond's testimony. Can Mr. Bugelman's maybe point to the date or the docket number on the PSC website to where that supplemental plan can be found?
Respectfully, it's not my job as the counsel for the applicant to help you cross-examine our witnesses. But you can find it in the docket under PPRP's main submission where they submitted their direct testimony.
You're speaking of the PAR, correct, Mr. Bugelman's?
Correct, Your Honor.
Do you have the PAR, Mr. Drummond?
Yes, it's attached to Mr. Sadinsky's direct testimony from December of 2019.
Okay, well, why don't, from that document, how about you ask the witness a question about the boundary that you're interested in, and then we'll get to whether it contains the information you're looking for with regard to an updated boundary.
Don't want to fence with anybody, but the so-called the PAR, the Project Assessment Report, to my knowledge, does not have a graphic showing the critical area line as it existed before the new GIS maps were adopted by Kent County.
I understand not before, Mr. Drummond. I thought it might be helpful to elucidate worthwhile testimony if you started with what I understand is available, which is what the witness testified regarding a boundary that existed at some point in time. Can we start there? Do you have the PAR, Mr. Drummond?
I'll ask it. Mr. Clark, directing your attention to the project assessment report for Morgnec Road Solar dated December 17th, 2019, attached to Mr. Sadinsky's direct testimony. Could you direct my attention to any graphic in that report that shows us the critical area line prior to the adoption of the new critical area maps by Kent County?
I do not have that testimony in front of me.
Mr. Bugelmans, can you please email this to your client?
Yes, Your Honor, I'll do it now.
Your Honor, I know it's difficult, but Mr. Drummond's sound is weak. If he takes off his picture, it comes in real good. So I know that's a problem. But
Mr. Drummond, for best audio quality, if you could turn off your camera. The court reporter is indicating that your audio is much better when your camera is off. Thank you.
I'm going to download this really quick, if that's okay with Your Honor.
Please, I think I believe your testimony was that you believe that there's something in this document responsive to Mr. Drummond's questions. So I'd like to see it.
Well, actually, my testimony was I believe that it was submitted. I did not testify that it was in
I'm
this.
sorry, your counsel seemed to indicate it was in this document. So it's kind of a combination of what your attorney has said on your behalf and your testimony. If you can help us out, I'd appreciate it.
Definitely. It's me. I'm going to look again. I do not see the design in this document. There is a critical area drawing, but it is not the updated one.
Okay, where's that? Is it in response to PPRP data request 1-10?
The critical area graphic is on page 29.
Thank you.
Your Honor, if I may, I believe there's something in Exhibit 5. The first page of Exhibit 5 might be the critical area map that he's trying to locate.
That you sent this morning?
No, Your Honor, this is Appendix 5 of the applicant's ERD. That's where the critical area map was included.
I'm sorry, Mr. Bigmans, did I, maybe I didn't understand you correctly. I thought you said the PAR, but did you mean the ERD?
I did not, Your Honor. And I mean, if I referred to a map, I misspoke. I do think the critical area issue is dealt with in the PAR and in PPRP's conditions, including condition 15. But I don't want to, tell our witness what to say. So I just,
Okay,
I'm
no,
trying to be
that's fine.
cautious.
I saw a discussion in the PAR about the critical area. And then the map on page 29, I'm not sure if that has the information or not. If I zoom in, I think that's land use.
Your Honor,
I see critical area residential in yellow. Is that, Mr. Clark, are you trying to explain to me whether I have the right information with this map?
yes, Your Honor. This is not the site plan that was created by the consultant of Urban Grid. This is a land use overlay using the Kent County mapping tool.
Okay, so if we go instead to the ERD, and I heard Appendix 5, which is Critical Area Commission Confirmation Memo. Is that,
I think the rest of the ERD has.
you have the ERD, correct, Mr. Clark?
Yes, Your Honor, I do.
Okay.
If it helps, Mr. Clark, it's on what it looks like you have it printed out, but it's page 157 of the PDF. So
Yeah.
near the back.
Not seeing a page 157, unfortunately. Sorry, you probably couldn't hear that. I am not finding page 157.
I heard that. 157 of the PDF.
Is it okay if I open it on my computer, Your Honor?
That's what I'm doing. I think that's fine.
Okay.
Yeah, Mr. Buglins, the PDF I have is only 132 pages. Did I not understand you correctly?
I think what happened is, Your Honor, is the document set that we're using, it's both the ERD and the appendices combined.
Ah, okay.
So with that, it's 157. So I won't try to do the math for you, but
Okay,
ground.
I'm at Appendix 5.
Yeah, it's a big green page. It says it-
107,
Yeah,
page 107 of the PDF, Mr. Clark.
Okay. Let's try this one. And the page number again was 157?
No, 107.
107. Thank you.
although Mr. Clark, if it's the version that we provided you for your virtual binder, it may be 157. I'm sorry to add to the confusion even more.
We'll get there. It's all right.
It's all right. Okay. I'm going to try the virtual binder. Okay. ERD. Thank goodness. Okay, 106. So 150 something. It's taking my computer a while to catch up with my scrolling, unfortunately. It is not page 157. What was the other page number?
How large is your PDF?
That's 58.82 megabytes.
No, no, no. I'm sorry, how many pages?
182.
Okay, towards the end of the document, do you see Appendix 5 in a green kind of cover page?
Just past that. I do, yes.
Okay, and then below that, there's a map of sorts.
Got it.
Can you tell me what that map is?
That is not the map that we submitted as an alternate site plan.
Okay, do you know what this map is at all with respect to critical area?
Yes, the green shading is the RCA critical area.
Okay, so this would have been the boundary, the green shading, the boundary of that green shading would have been the boundary prior to when the county updated it?
That is correct, Your Honor.
Okay, then you also believe there's a site plan somewhere in the world that has that boundary as well?
Yeah, I can assure you that it exists in the world. It's in my database right now, but if I could elaborate on the submission.
Why don't you hang on just a second? Mr. Bugemans, do you have a position on whether the site plan can be made available to the parties at this time?
We could certainly make the site plan available. I think I've been looking through my files trying to find it. I would add that that is also iterative because the settlement was not part of the equation when that site plan was created. So, it's a snapshot in time and it should show avoidance of the revised critical area boundary, which again, under PPRP condition 15, that area needs to be avoided. So regardless of whatever the final site plan looks like that's approved by the county, that condition would require that area to be avoided. It's the law of Maryland in addition, irrespective of the condition. So I just wanted to qualify it. Any site plan at this point is not what's being approved if the CPCN is issued here, because ultimately the final design will have to go through the county's technical review, which will dictate the final layout, consistent with the condition and whatever, consistent with the settlement and whatever conditions to the CPCN are adopted.
Yep. Understood. What I was trying to do is just get information to Mr. Drummond that he doesn't appear to have.
Judge Lawrence, a couple of things. I was under the impression, perhaps mistaken, given my lack of experience with commission matters, that we were considering an application of as submitted, and we were to give some reliance, or we were to rely upon the application as submitted. If the project has changed as the result of the change in law, then we would have expected to receive a graphic illustration of the project now, for which approval is now sought. Moreover,
I think what Mr. Bugelman is explaining to you is that if you read the conditions that are in the docket, I'm not sure a visual representation is necessary.
the law, Mr. Bugelman is incorrect about the status of the law regarding solar arrays in the critical area. Now, I'm led to understand
That's not what he said. He was explaining that there's a condition that PPRP has recommended the commission adopt, which would require avoidance of the critical area, making a map of the boundary with respect to the solar panels largely unnecessary. Just be a picture showing what the condition would require. And as Mr. Bugans went on to note, that after this process, there's still a process at the county. So I'm not sure that you're
I
really.
completely understand that. However, the recommended condition number 15. Condition number 15, as proposed by PPRP in the settlement agreement, is inconsistent with the current status of the law regarding solar arrays in the RCA. The current law is set forth in COMAR 270204G. And this arises because solar panels are now permitted in the RCA under certain conditions.
Okay, it sounds as
And
though
there's-
then you have some questions for Mr. Sadzinski about condition 15. But I don't think there's
Right.
anything else Mr. Clark can provide you under this line of questioning. He's answered your questions to the best of his ability, as far as I can tell, with regard to solar panels, no solar panels in the critical area. You're now telling me the law is they can be. That's fine, and you can inform me as to the law in your post-hearing brief, and you can ask PPRP's witness about whether they took that into account. But Mr. Clark has answered your questions. Do you have any further questions for Mr. Clark? And again, if you would turn off your camera, your audio sometimes patches in and out.
I don't have any other questions of Mr. Clark, given I don't have any other questions.
Mr. Yeager, do you have any questions for this witness?
Yes, I do. So, Mr. Clark, I take it when you were giving your testimony, excuse me, you were doing that with the assumption that the solar panels were not allowed in the resource conservation area of the critical area. Is that correct?
The redesign that Urban Grid performed on this project, stretching to the new critical area boundary, was performed before the new regulations were adopted through
So
State Kumar.
it was done with the understanding and belief that you could not put the panels in the RCA.
That original design, that is correct.
Okay, thank you. So you are aware now that panels could be put in the RCA?
I am aware and I am quite familiar with the new law, and there are many issues that would still prohibit us from doing that, such as forest removal limits and steep slopes and sensitive areas.
Now, Mr. Clark, you have adopted Mr. Thompson's testimony, is that correct?
Yes, sir, that's correct.
And Mr. Thompson in his testimony, and I could quote lines, but it's throughout, Mr. Thompson indicates that he performed an analysis of the Kent County zoning map, and throughout his testimony, he discusses that analysis. Do you agree with that?
I do agree with that.
And when did Mr. Thompson conduct this analysis?
I don't know that exact date. I do not know that exact date.
Do you know the approximate date when he conducted this analysis?
I would be afraid to speculate on that. I do not.
So when Mr. Thompson conducted this analysis at some time unknown to you, did he work alone, or did he have a team, or did he have assistance on this project?
I do not know that answer. I was not employed by the company when this was done.
Okay. So you do not know if Mr. Thompson was self-supervised or if anybody supervised him during this time?
I do not know that answer.
So as I see it then, you're adopting Mr. Thompson's testimony of an analysis that was done at a time unknown to you before you joined the company, and you do not know who supervised Mr. Thompson, who assisted Mr. Thompson, and who worked with Mr. Thompson.
Objection.
Basis.
Mr. Clark, at the start of his testimony, testified that he's redone Mr. Thompson's analysis and agrees with his conclusions, irrespective of what Mr. Thompson did when he prepared this document.
Then Mr. Clark should have prepared his own testimony with respect to his analysis rather than adopting Mr. Thompson's testimony. I
Okay.
move that his testimony be stricken.
Okay. That motion's denied.
I have nothing further. Thank you.
Okay. Any redirect?
I do have one clarifying question, Mr. Clark. Is the project going to locate panels within the RCA?
There are no plans to do so as of today.
Thank you. I have no further questions.
Thank you, Mr. Clark, for your
Your
testimony.
Honor,
Oh, I'm sorry, Mr. Hicks. I don't know how I forgot that you were also with us. I apologize.
I guess I'm easily forgettable. That's all right. So, just to, and briefly, morning, Mr. Clark. How are you?
Great. How are you, sir?
I'm good. My name is Jesse Hicks. I'm with the town of Chestertown. In regards to the other sites that were analyzed by Urban Grid, did you ever make any site visits to those?
I did. Yes,
Okay.
sir.
And as far as your analysis of those sites, was that just the direct testimony of Mr. Thompson, or does he have other reports that he prepared for each of those sites?
The testimony includes the GIS report that was done. However, I can't confirm that Mr. Thompson performed site visits. I can verify that I did, and I reran using the same zoning map that is on Kent County's website that is accurate as of 2003. No zoning has changed, according to the Kent County website. The map viewer, to be exact.
And are you referring to the critical area as far as zoning?
No, I'm referring to the zoning layer that is on the Kent County map viewer, as well as the critical area layer that is on the Kent County map viewer.
Okay. You mentioned prior to your testimony that you're familiar with the typical ways that Urban Grid selects their sites.
That's correct.
Okay. And if I'm reading the testimony, it's in Adam Thompson's testimony. It is page 10, 18 and 19. Access to
Bear with me 1 second.
I apologize. I'm moving a little quick.
I'm on paper here. So, okay. Page 10, lines 18 and 19, you said?
Yes.
Okay.
And I'm just going to read from it. When searching for project sites, our team looks at access to transmission infrastructure, availability of clear, relatively flat land, and local jurisdiction first. You see that?
I do, sir.
What you just described, what does local jurisdiction first mean?
I'm going to speculate that
I'm not asking you to speculate.
I don't know that answer.
You don't know.
Not.
Okay. So as far as that consideration in selecting a site, you don't know what that means.
I do not, sir.
Okay. And access to transmission infrastructure. You said you're familiar with that, correct?
Yes, sir.
And the purpose of that, I would assume, is the economics of connecting the substation to any other type of infrastructure.
It's economic, and it's also the closer proximity to the site, to an existing substation, is less disturbance for the subject land and any lands between the two.
Okay. And then obviously clear, relatively flat land leads to the where the solar panels can be placed.
That, and the fact that we typically try to find properties that will not require deforestation.
Okay. And you would admit that there is a number of flat lands that wouldn't require deforestation in Kent County.
I would agree with you, sir, but not suitable for solar.
But there are other solar farms that have been proposed and have been constructed in Kent County. You would agree?
I would agree, and both of them were directly next to a substation.
Fine. I'm going to get to your supplemental testimony, supplemental rebuttal testimony that you filed on October 29th.
Okay.
You have that in front of you?
I do, yes, sir.
Okay, and so it's mostly in reference to any type of inclusion into the Underground Railroad network to freedom. Is that correct?
I'd say that's a safe assessment, yes.
Okay, and it's your understanding that and just for background, its inclusion would be in reference to, I believe it's Ms. Fritz's testimony, Ms. Christensen Lewis testimony, excuse me, that potentially this could be part of the National Underground Railroad network to freedom, correct?
That is correct.
Okay, and your testimony is that the development of this solar project would not interfere with that designation.
We would not, and we would also be supportive of it, as would the property owner.
Right, and you state that you would be supportive of it by placing a landmark on the outside of the solar farm and placing, I think, the logo on the project site.
Yes, sir. We use that We use that example because that's typically, well, that's the way I have read the structure of the program.
All right.
As well as access to funding, which we wouldn't ask for.
Right. And well, are you familiar with where the location of the previous homesteads were on the property?
I am, yes, sir.
Okay. And so that would lead us to believe that that is where essentially the Underground Railroad designation would be, correct?
Objection.
I don't think that's correct based on the testimony I've read. You just said that the designation would be outside the facility. Well, it's along the road, right? I don't think the houses are along the road. I could be wrong.
That's my point. Let me rephrase. I apologize, Your Honor. So I'll withdraw that question. And Mr. Clark, the houses are the reason. The houses on the property are the basis for that designation, correct?
I disagree. The basis for that designation was that a certain individual worked on that farm.
And potentially lived in or around those houses.
Objection.
I'll allow the witness to answer if he knows.
Could you ask that question again, sir?
You said that it revolves around an individual who worked on that farm, correct?
Possibly worked on that farm.
Possibly, and also then possibly lived in or around those houses on the property.
I have no knowledge of that. It could have been an entirely different house.
That's fair. If there was any investigation or a historical investigation into that information, and it did indicate that this individual lived on those houses, would it be fair to say the public would not be allowed anywhere near those sites?
I have no knowledge.
Objection. He's not citing to any place in anybody's testimony where that's stated, including the application, which he could be referencing.
That's
there's no
okay.
basis for the question.
I think your witness was starting to answer, and I think he's capable of answering, even though it's probably not a great question.
It's probably not a great question, but if I may, Your Honor, what the designation is, I think in previous witnesses has come up, would be around the Hopewell, the two homesteads from the 19th and 18th centuries.
Where's that?
Where is that?
Where's that in testimony?
I believe it was in testimony of the first witness, Mr. Dr. Otter.
I don't recall that. Do you want to point us to that? Or was it oral, are you saying?
I believe it was oral. I believe I don't have the testimony directly in front of me.
I don't recall anything about the designation being placed near the homesteads. That
No,
doesn't
no. I didn't mean that. What I'm saying is that the property, that the two houses, that is the basis for any type of designation or archaeological research into the property for historical context.
Yes, but that's not necessarily related to the Underground Railroad, in my understanding of his testimony.
Correct. And that then comes up in Mr. Clark's testimony, his supplemental testimony, when he talks about if there was a designation for the Underground Railroad.
Where's that?
It's in his supplemental testimony dated October 29th, 2021.
Yeah, I have it. What page?
There would be 2 through 4. In regards to acceptance into the Network to Freedom.
You said supplemental direct?
Supplemental rebuttal, excuse me, dated October 29th, 2021.
Okay. And I'm sorry, then you were at page 234, you said?
Yes, ma'am.
Okay. Um, okay. I don't see designation related to the homesteads. Wasn't that your question? I see Dr. Edward Otter does not believe there are relevant historic deposits remaining on the project site. I see that. And then I see that acceptance into the network to freedom would not disturb the development of the solar project
Hmm.
because it would allow the applicant and landowner to use the network to freedom logo on the property.
Hmm.
Okay, so I'm sorry, what's your question?
Well, my question would be, to the extent that Morgnec Solar would recognize network to freedom would be allowing the applicant and landowner to use the network to freedom logo and make the property available or eligible for grant funding, but you said you wouldn't take advantage of that.
Likely not. But also, we also have the opportunity to take part in this program as part of our public amenities portion of our settlement agreement.
What program? Are you referring to the Network to Freedom program?
Yes, sir, I am. We expected that to be part of our public amenities, which would be out in front of our project, which is part of our settlement agreement.
Okay. And on page 4, you say the applicant would be supportive of including a historic marker and/or other interpretive historic elements
That is
on
correct.
as part of the National Underground Railroad Network to Freedom.
That is correct.
It would not stop you from placing the solar farm on the from developing the solar farm on the property. You would just place a logo on the outside of the property.
I'm not sure that's how it will end up. That's going to be through the negotiations of how the public amenities pan out. That's one option. Yes, sir. Yes.
Okay. Thank you. But safe to say that would be the only, well, excuse me, the interpretive historic elements of the historical marker would be the only portions of the National Underground Railroad Network to Freedom that would be placed on the property. You wouldn't allow the public into the solar farm if there was any type of investigation done to the property that concluded that there was a self-emancipated slave through the Underground Railroad.
The network to freedom does not require that the program does not require any access to the property. That I will give you as an answer.
Okay. Thank you. I have nothing further.
Mr. Bugelmans, if we go back to page 10 of the direct testimony of Adam Thompson, in addition to striking lines through 10 through 12, I'm going to strike line 18 through 19 when searching for well, actually, no. Mr. Clark, you told me that you were familiar with your team's process. And then when Mr. Hicks was asking you questions, you were able to say that you were familiar with the access to transmission infrastructure, the availability of clear, relatively flat land, that those were part of your process, but you had no idea what "and local jurisdiction" first meant. So is it your testimony that to your knowledge, that's not part of your team's process?
I would say that that is not part of the process that I'm familiar with.
Okay, so I'm going to strike the comma and local jurisdiction first, those 4 words. So it'll end with relatively flat land, period. Other than that, the exhibits, applicant exhibits, well, there are no objections, I don't believe, to 28, 30, and 31, but 28, 29, 30, and 31 will be admitted into the record. Mr. Bigamans, do you have any redirect at this time?
I have no redirect, Your Honor.
Okay, thank you, Mr. Clark, for your testimony. You're excused.
Thank you, Your Honor.
Mr. Bigamans, I am guessing that the testimony of Mr. Stevens will take some time.
I think that is likely, Your Honor.
Okay, so we're going to break for lunch now, and we will come back and reconvene at 12:45. Thank you.
Thank you.
Actually fun.
Mr. Court Reporter, are you ready?
You're on the record, Your Honor.
Thank you. We're back on the record in case 9499. I'm trying to determine who is creating the feedback. I'm muting you, Mr. Stevens, and you, Mr. Albert.
Your Honor, can I make I just wanted to make a short statement, if I may?
Pertaining to what?
We, bear with me, I'm pulling this up. At the very beginning of this hearing, you set a ground rule of, as you said, no friendly cross.
That's correct.
And as how that played out was when these project's witnesses took the stand and you went party by party with respect to cross, you did not ask staff if they had any objections, any questions, any cross-examination, I should say, for the witness. Staff, I apologize, obviously the horse is out of the barn and we're not asking for any witnesses to be recalled, but we were puzzled by that. We certainly understand the ban on friendly cross, but that was not what staff was planning on doing. We did have very limited cross of certain of the project's witnesses where the intent of the cross was not a sort of sneaky attempt to support or bolster the witness. But instead, we did feel that these questions were necessary to ensure a complete record. If I can just give you a couple examples, we wanted to ask.
If the witness has already been excused, I don't need the examples. Mr. Albert, you should have spoken up at the time.
That's certainly correct.
I'm aware of the subject of staff's witnesses' testimony, and it's fairly limited. So I certainly didn't anticipate you had questions in some of the areas that the witnesses have been discussing. And as I said, you have spoken up a couple times during this hearing for clarification of various items. So I know you have the ability to speak up when you need to. So no point in rehashing what you failed to do. Going forward, if you have a question for a witness, please speak up.
Thank you, Your Honor.
Okay, Mr. Stevens, I'd like to do a sound check right now. I'm going to unmute you. Guess what I actually did was send a request that you unmute yourself.
Can you hear me okay?
I can. You're pretty loud. I also
right.
hear an echo of myself back from your computer. So if you could turn down your computer.
That will take me just a minute, Your Honor. Is this any better, Your Honor?
Let me see when I speak. A little bit of my voice in the background.
Yeah,
Mr.
no,
Court
I'm
Reporter.
having trouble hearing you, Your Honor. I turned it down a little more.
Do you have headphones available to you, Mr. Stevens?
I do not believe I do.
Okay, well, I certainly want you to hear me and the questions that you're being asked. It's not good for the court reporter to get feedback of my voice from your computer in addition to.
Yeah, I understand. I understand. Let me see if I can get my headphones working and I'll be right with you.
Okay.
Your Honor, can you hear me now?
I can hear you. I still get a little bit of an echo back, but it's not as bad, I don't think. Mr. Court Reporter, how's the sound?
I agree, but he can mute himself when he's, somebody else is talking.
Okay. Mr. Stevens, can you hear me okay?
I cannot hear you now.
Well, that's a bigger problem. How did you answer my question?
Just have him mute himself when, it takes a little more time, that's all.
Okay. Do you understand, Mr. Stevens? You're going to have to mute yourself whenever you're not speaking.
Let's see.
Down the bottom where it says mute, unmute. Mute.
Okay, yeah, I understand. I was just addressing that with my headphones. So you can hear me now.
Yes.
Correct. Okay.
Now I can't. Okay. Mr. Bugelmans, your witness. Mr. Bugelmans, I can't hear you.
Sorry, Your Honor, that was my dual mute button issue. I'll begin with the attestation. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Okay, and that witness is?
Oh, I did not call Mr. Stevens. Mr. Joseph A. Stevens, Esquire.
Mr. Stevens, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Bugelmans, please proceed.
Thank you, Your Honor. Mr. Stevens, can you please state your name and provide your business address?
Joseph Stevens, 114 West Water Street, Centerville, Maryland.
And what's your company and title?
Law Offices of Stevens Palmer, LLC.
Could I
Mr. Stevens,
get you a spelling of your name, please?
JOSEPHSTEVENS.
Thank you.
sure. Mr. Stevens, do you have before you a document entitled Direct Testimony of Joseph A. Stevens, Esquire, dated August 2nd, 2019, consisting of 222 pages, inclusive of attachments?
I do.
Your Honor, I would like to request this document be marked as Applicant Exhibit 32.
So marked.
Thank you, Your Honor. Mr. Stevens, you also have before you a document entitled Rebuttal Testimony of Joseph A. Stevens, Esquire, dated March 20th, 2020, consisting of 34 pages, inclusive of attachments.
I do.
Thank you. Your Honor, I would request this document be marked for identification as Applicant Exhibit 33.
So marked.
Thank you, Your Honor. Mr. Stevens, were these documents prepared by you or under your supervision and control?
Yes.
If I were to ask you the same questions today, would your answers be the same?
Yes.
And is your testimony true and correct to the best of your ability?
Yes.
Thank you, Mr. Stevens. With that, Your Honor, I'd request to move Applicant Exhibits 32 and 33 into evidence.
Any objections? Hearing no objections, applicants' exhibits 32 and 33 are entered into the record.
Thank you, Your Honor. And with that, Mr. Stevens is available for cross-examination.
Mr. Drummond.
Thank you, Judge Lawrence. Stevens, as you know, I'm Chris Drummond. I represent Kent Conservation and Preservation Alliance. Mr. Stevens, you and I have known each other for 30-some years.
Yes,
And at least in the beginning of those 3 decades, you were employed by Queen Anne's County. Is that right?
that's correct.
In what capacities?
I was the environmental planner from 1985 to 1987. From 87 to 88, I was the deputy director of the Department of Planning and Zoning. And then from 88 through 93, I was the deputy director of Planning and Zoning from 88 up until 88. And then 88 to 93, I was the director of the department.
And it's correct to say that you and I worked together from the late 80s through your departure from Queen Anne's County in 1993. Is that right?
That is correct.
And during your tenure with the Queen Anne's County Department of Planning and Zoning, how many comp plan updates were you involved with?
Well, I was involved in a complete comprehensive plan and rezoning rewrite in 1987, began in 85 through 87. Then I was involved in the update in 1993 to the comprehensive plan that started a couple of years before that. I've also been involved in several area plan drafting. I was involved in the original critical area program drafting for Queen Anne's County, as well as the critical area ordinances that have been adopted in Queen Anne's County up and through 1993.
1993, in your law practice.
I'm sorry, I'm gonna have to stop you there. Mr. Stevens, you're gonna have to mute when you finish talking. I appreciate that.
1993, you've been engaged in the practice of law, and that's been primarily land use law. Is that right?
Yes.
That's representing, by and large, developers' interests.
I've represented several municipalities and counties as well, Charles County being one, Frederick County, Talbot County, and Queen Anne's County on land use related matters, as well as a couple of municipalities. Town of Easton being the more recent.
Largely representing developers.
The majority of my practice is representing the private sector, whether it be developers or property owners or business owners.
That background, it's fair to say that you are very familiar with the status of the law in the state of Maryland regarding consistency of land use regulations with comprehensive plans.
Yes.
Okay. Mr. Stevens, do you agree with me that zoning codes, zoning ordinances, and zoning maps adopted by either a county or a municipality that's exercised its planning authority are presumptively consistent with the adopted comprehensive plan?
Yes, generally.
Moreover, that the zoning codes and zoning maps, which are presumptively consistent with the comp plan, implement the goals and objectives of the comprehensive plan.
Yes, generally.
Clear with the intent set forth in the Kent County Code for the community residential district?
Yes.
That intent would be to provide for single-family residential development in areas of existing residential development, together with facilities and accessory uses normally compatible with residential surroundings, and at the same time permit agricultural uses and to preserve open spaces and rural character. Did I correctly read the intent?
I assume so.
Are you similarly familiar with the intent of the rural character district as set forth in the Kent County zoning code?
Yes.
And that purpose is to provide for the market demand for rural lots, including estate lots, in a manner that maintains rural character in a location that minimizes conflicts with agriculture. To maintain the rural character and developments will follow strict guidelines for protecting significant rural features.
Mr. Stevens?
Yes.
I don't want you to assume that Mr. Drummond has read something correctly. So if you need to refer to something, please do so or ask him to refer you to a document. Don't make assumptions.
All right. Mr. Drummond, could you refer me to a document? I can't, because I cannot, verbatim say that that's what it says. It sounds generally consistent with what is in the zoning ordinance.
For you to forward it to Mr. Bugelman's the other day, which is section 6.1 of the Kent County Code, and section 3.1 of the Kent County Code. I suspect you have that code in your office.
The only items I have before me is my testimony and rebuttal.
I think I've identified the email that Mr. Drummond's referring to, and I'll forward it to Mr. Stevens now.
Can you CC me on that, please?
CC everybody on that.
Yeah, let me, I will reply all and add the judge and just, sorry, I have to pick through this chain of emails here. Okay. You know what?
I believe I found a document. I have section 3, rural character district, and section 6, community residential. It's not clear what this excerpt is from, but I have that if that's what's being referred to.
I think that's correct, Your Honor. That's what I just forwarded to everybody.
Thank you.
May take a few seconds, Mr. Stevens, for it to show up in your inbox.
I don't know if I can authenticate something, but I can attest that this is out of the land use ordinance of Kent County. It looks like it's photocopied right from the land use ordinance. I'm familiar with that document, and it looks like these are pages that were photocopied right out of the Kent County land use ordinance, if that's any help to anybody.
I was hoping Mr. Drummond would lay a foundation for what he's asking the witness to look at and confirm the language of. It's his exhibit.
When I asked Mr. Stevens if he was familiar with the statements of intent of the 2 zoning districts, he said he was.
Yes, Mr. Drummond, but then you quoted them and asked him if that's what they said, word for word. And he said he assumed you read it correctly, and I said I don't want him to have to assume. Do you understand where we are? He's going to have the document in front of him, so he doesn't have to assume you've read it correctly. He did say he was familiar, but he also said he can't say it says exactly the way you said it verbatim. Do you understand?
You and I seem to be having.
You can't hear me?
I can hear you fine,
Okay.
Judge Lawrence. And I appreciate the continued admonishments.
They're not admonishments, Mr. Drummond. I'm trying to run a hearing.
I have them open if Mr. Drummond wants to read them again. Otherwise, I am generally familiar with them.
Again. You agree with me that the statement of intent for the community residential zoning district in Kent County is the purpose of this district is to provide for single-family residential development in areas of existing residential development, together with facilities and accessory uses normally compatible with residential surroundings, and at the same time to permit agricultural uses and to preserve open spaces in rural character. Did I correctly read it?
Yes.
Okay. Let me read the statement of intent for the rural character district, Mr. Stevens, and make sure I correctly read it. The purpose of this district is to provide for the market demand for rural lots, including large estate lots, in a manner that maintains rural character and in a location that minimizes conflicts with agriculture. The district may function as a transition between towns, villages, residential developments, and the agricultural zoning district. I correctly read that?
Yes. You read the first half of it correctly.
Stevens, are utility scale solar projects permitted in either the rural character or commercial, not commercial, I'm sorry, community residential districts
No.
in Kent County?
No.
Okay. Following the tautology that you and I just engaged in, utility scale solar projects are not consistent with the Kent County Comprehensive Plan.
No, I wouldn't agree with that. Following the logic that you just tried to lay out.
Well, let's go
There
over
are
it again.
lots of, I'm sorry?
1 second. Let's go over it again. Zoning codes and zoning maps are presumptively consistent with adopted comprehensive plans. Do you agree with that?
Yes.
Zoning codes and zoning maps implement comprehensive plans. Yes?
Yes.
And the statement of intent for the rural character and commercial character district, not commercial, keep saying that. Community residential districts are as you and I have just gone over. Correct?
Yes.
And utility scale solar projects are not permitted in either of those districts.
That's correct.
Utility scale, perhaps I'll rephrase the conclusion from that tautology. Utility scale solar projects are presumptively inconsistent with the Kent County Comprehensive Plan.
Well, from the logic that you laid out, that's certainly an analysis that one could make. However, zoning ordinances and zoning districts have lots of uses prescribed in them that are not necessarily stated in the intent statement of those uses. So clearly a special exception or something of that nature, some other use within a zoning district that doesn't necessarily fall within the purpose and intent statement, you'll find quite often in that regard. In regards to
Mr. Stevens, that's why I asked you whether utility scale solar was a permitted use in either of those zoning districts, and you acknowledged that they are not.
It is not, no.
Are they permitted by conditional use or special exception?
No.
Mr. Fairway, I'm Need to get to your direct testimony. I've lost it for the moment. I've lost it for the moment. Hold on a second, please. Mr. Stevens, on page 12, lines 1 through 3, your direct testimony, you direct our attention to pages 87, 88 of the Kent County Comprehensive Plan, correct?
Yes,
And I correctly understand your testimony to be that the solar project is somehow consistent with the comp plan because it, among other things, will demonstrate stewardship to the lands and waters. Do I understand that testimony correctly?
I indicated on page 11, line 22, that I was citing the reasons in the narrative as to why the project was consistent, as explained in the narrative that was submitted with the amendment to the zoning ordinance. And I cited that provision in that regard.
Are
In
you saying
support.
that, are you saying that you're in your direct testimony that you do not advocate that the solar,
Mr. Stevens, you have to mute. Sorry.
do not advocate that the proposed solar facility is consistent with, in part, with the comprehensive plan because it will demonstrate stewardship to the lands and waters? Is that not your
No.
position?
What that cites that provision of the comprehensive plan. My testimony is in regards to the totality of the comprehensive plan, both for Kent County and for the town of Chestertown. And that the comprehensive plan is such that it can be read that in this growth area, and it is in a growth area, that this use that has a specific lifespan or time frame is consistent with the comprehensive plan because it can hold this property, which is not necessary for development during the 30-year period, because there's plenty of other opportunities and places for development. Meet this goal in the comprehensive plan that you just cited, Mr. Drummond, about stewardship, preservation, sustainability, and then be available at the end of that 30-year period and still continue to be a growth area. It's a totality of looking at the plan and not just looking at one particular word or one designation of the property. The property is designated in one of the several growth areas for the town. But as explained, I think the property can be developed for a solar facility, and that would be consistent with the overall goals of the plan because it will be available for development in the future.
Stevens, what's a PFA?
I don't think he heard you because you were very faint.
What is a PFA?
It's a priority funding area.
And could you describe the significance of a priority funding area?
The priority funding area is an area where the state recognizes that it will help fund infrastructure. It's indicated in growth areas, and in Kent County, in particular around Chestertown, there are several priority funding areas outside of the town, as per the map I indicated, which I can send everybody to.
One of which is a large chunk of the property proposed for the solar project, correct? You've muted yourself, Joe.
I'm sorry, I'm getting confused with the mute, unmute, and my apologies. About 200 acres of the 500 plus is in a PFA on the northern portion of the town, along with several other properties, both on the northern portion of the town and the northwestern portion of the town.
The PPA.
I'm sorry, could you repeat that?
What is a PPA?
That is a priority preservation area. It's an area designated by the town, by the county, for efforts for agricultural preservation, as I understand it. And this property is
You agree
not
with me?
in a priority preservation area.
Can't be both, can it? Can't be a PFA and a PPA.
No.
Right. You know when in your research, do you know when this property was zoned in the CR and RR districts?
I do not.
That would be relevant to your claim that the property will not be needed for residential development for the next 30 years?
My claim is based solely on the language in both the Chestertown and the Kent County comprehensive plans. I did no separate analysis. I just evaluated those plans, and what I cite in both my testimony and the rebuttal are direct citations from those plans that indicate the amount of developable area in the town of Chestertown in the form of infill development, as well as other sites designated for growth outside of town. And then in regards to the Kent County comprehensive plan, we looked at the number of vacant lots available for, as cited in the plan, available for development, using presumptions that both the county and the town applied to discounting the number of lots in case of not developable, lack of perk and other zoning restrictions or restrictions they might have. And that's the basis of my analysis, as well as the fact that Kent County has other municipalities that will accommodate some growth. Looking at the county's own projections and the town's own projections and comparing them to what's available leaves, the only conclusion is really that there's just a great deal of land available to accommodate growth that's projected by the county in other portions of both land in Chestertown, around Chestertown, and around the other municipalities, and in the county in general in the form of existing lots. And so,
okay, Mr. Stevens. Okay, that's fine. When you were involved in the creation of community area plans and growth area plans in Queen Anne's County, for those growth area plans, strike that. Did the county count up the number of undeveloped lots in other parts of Queen Anne's County? Determine the capacity of the population capacity of those lots before designating the growth areas in Queen Anne's County?
I can't recall.
You and I both, well, okay, I'm not supposed to say that. You don't recall that?
No, I don't recall. And my assessment of those lots is not based on something that I just pulled out of thin air. I just went to those plans, those policy documents, and used those as the basis to form my assessment.
To investigate how many of the lots that you claim are available for development in Kent County are the typical 1950s, 60s, and early 70s 50 by 100 foot lots that wouldn't have a chance of perk?
The plans themselves made investigations into those. In those planning documents, they were done fairly detailed. For example, in the Chestertown planning document, which is noted on attachment G of my rebuttal testimony, you will see on page 80, I'll give everybody a second to get there.
Okay, you go right ahead.
Okay, on page 80, it talks about infill. This is where the town does an infill development capacity analysis. And if you read through that, you can see that they only identified 25 key vacant parcels that could support infill development, and that the town themselves analyzed each of these parcels to determine what a realistic development scenario would be for those parcels. It just wasn't something pulled out of thin air. And that they came to the conclusion that that after they did discounting for what might not be available if you couldn't develop under the full zoning capacity, that there'd be about 990 future residential units available in that infill. The page 82 shows what the town did. They numbered each of those 25 parcels. They took the size, the zoning, the units per acre they think it could support. So it was a very detailed analysis. In fact, it's something that I haven't seen in a whole lot of plans, although municipal plans may carry it more often than county plans.
That's not what I asked you, Mr. Stevens. That's not what I asked you. I asked you about the county.
I was just going to get to that. If you look at my same testimony rebuttal attachment D, the county wasn't nearly as detailed, but the county does cite, and I'm at the top left-hand corner of what's shown as page 6 of 130 of the Kent County 2018 Comprehensive Plan, and it says subdivision activity. The number of existing undeveloped lots in the county could satisfy projected population growth for more than 30 years, the next 30 years. And then it says the number of lots. In 2015, Kent County had 3,761 unimproved parcels, representing 28% of the number of parcels in the county. Although many of these parcels may not meet current health department or zoning standards, preventing their development, many will be able to meet these requirements. I assume many meant more than half, and when I did just some thumbnail assessments. So when you take those two together, there's a significant amount of simply existing lots or infill development, not even counting for other growth areas around Chestertown and other municipalities.
Done. Finally,
Yes.
Mr. Stevens. In other words, you don't know how many of the 3,700 lots that are referenced in the Kent County Comprehensive Plan that have not been developed could be developed under current health department, environmental, forest conservation, critical area, and other requirements. You don't know.
I relied on what was in those planning documents.
Simple answer. Do you or do you not know?
I know for Chestertown is a much more detailed analysis. So I think it's safe to say for the county, I only know what was recited in the plan. That's all I can testify to that I just read.
Lines 18 through 21 of your direct testimony. You state that the solar project would be consistent with many of the nearby land uses. I don't want to say our words to that effect. That's not
Mr. Drummond,
supposed to do.
I'm sorry to interrupt you, but you're talking to your paperwork over there, and you're not being picked up well on the computer. I'm sorry about that.
I apologize. On page 16, lines 20 and 21, you say that the solar facility is consistent with many of the land uses in the area near and around Clark Farm, correct?
Yes.
Describe those uses above that as commercial and light industrial.
Could you repeat that? I'm sorry, I missed the last part.
Describe those uses as commercial and light industrial to the south and west.
Yes.
Consequently, I take it that the solar facility would properly be characterized as either a commercial or light industrial use.
Could you repeat that? I'm sorry, Mr. Drummond.
Fair to conclude that the proposed solar facility would be characterized as a commercial or light industrial use.
I'm not making an assessment about its characterization, for a zoning district standpoint. We've seen these provided in many different zoning districts and allowed either by right or with conditional use special exception.
That's not my
Perfect.
question.
Let me
That's
just
not my question, Mr. Stevens. I directed your attention to your language that the solar facility, according to you, is consistent with many of the land uses in the area near and around the Clark farm.
Mhm.
Immediately preceding that statement, you described the surrounding uses as commercial and light industrial, the south and west, and agricultural to the north and east. Okay?
Yes.
Consequently, inasmuch as a utility scale solar facility is not an agricultural use, hope we can agree on that, it can only then be consistent with the commercial and light industrial uses to which you referred. Correct?
I am referring to the solar use being consistent with those commercial and industrial uses. Yes, I did not say they were inconsistent with agricultural or rural uses, particularly the ones that may not be developed. But I'm not sure I understand what you're asking me, Mr. Drummond.
I think you do, but you don't want to answer the question. Now, Mr. Stevens, across the street from the Clark farm in the commercial and light industrial uses to which you refer is a tractor distributor, isn't that right?
Yes,
A
I
farm
believe so.
A farm implement distributor, correct?
Yes, whatever I've listed there.
Many counties, such a use might not be called commercial, it might be called ag support. You agree with that?
Which uses are you specifically referring to as being ag support under the listing that I provided? Because I think maybe one or two of them could constitute ag support and the remainder may not. And it all depends on the jurisdiction. Some jurisdictions are very liberal as to what they consider ag support. Some are very conservative.
Completely agree with you, Mr. Stevens. Talking to me? Talking to me?
Yes, Mr. Drummond, I can't hear you.
I completely agree with what you just said. In some jurisdictions, farm implement dealerships are lumped in with ag support uses, are they not?
In some jurisdictions, yes, and to a certain extent with limitations as well. So sizes, what they sell, so it doesn't become a garden center, things of that nature.
I agree with that. Now, across the street, there's also a state highway administration facility. Is that right?
That's correct.
State highway administration subject to local zoning?
I can't say whether this type of facility is. Generally, state highway administration does pretty much what they want in the areas they want. Yes, you and I have gone around on in the past.
And isn't another one of the uses across the street the Kent County Ag Extension Service?
Yes, it is.
By its very name, Ag Extension Service, that use is connected to the agricultural industry or in Kent County, correct?
I'll agree. It's called Ag Extension Services, and they provide services to agriculture. Yes.
I think yet another use across the street is the county's Department of Public Works facility, correct?
Yes.
Finally, there is I think, correct me if I'm wrong, it's the old brickyard, and I guess I don't know what it's being used for now. You know?
I only know what was in the testimony, Mr. Drummond, after reviewing a Google Earth map. I might have taken a ride by back 3 years ago when we had the zoning amendments pending.
Not know that that property became a brickyard over 100 years ago before the advent of zoning.
Was
I
there a
do not-
question there? I didn't hear a question. I heard a
I
statement.
asked him if he knew whether or not he knew that that property was used as a brickyard for more than 100 years and before the advent of zoning and even the concept of comprehensive plans.
Which property are you referring to?
One to the furthest to the east and across the street.
Do you know what property he's
think it-
referring to, Mr. Stevens?
I generally do because I can remember the view of the Google Earth map, but I cannot answer him whether or not I know when it was built, Your Honor.
Okay. Mr. Stevens, you, I hope will agree with me that there are any number of reasons why land is not developed as might be permitted by a zoning code.
Yes.
And that no government through ordinance, maps, policies, arguments, incentives, any list I could come up with, can force a property owner to develop property as might be permitted by a zoning code.
Yeah, generally speaking, they do incentives at times, but that's really irrelevant to the discussion.
Use of land for that which is permitted by a zoning code is ultimately a decision to be made by the property owner.
Yes, generally speaking, sure, yes.
So the many so-called infill lots to which you refer may remain infill lots, notwithstanding whatever the town or county may wish to do with increasing population.
Yes, that goes for any land zone for development, whether it be in a growth area or anywhere, or agriculture. You know, you have certain uses you can do, a limited amount of subdivision. Yes, across the board, that's a general statement or accurate statement.
Consequently, the designation of properties favorably on a zoning map, the designation of properties, for example, as a PFA, and the relatively close opportunity for the extension of water and sewer might be the kind of incentive and policy-driven decision-making that would encourage the use of land, but would encourage a property owner to use the land for the uses permitted under the zoning code.
I think you misstated something there, Mr. Drummond. A property isn't zoned PFA. A PFA is
No, if I said that, I agree with you on that. I'd say favorable zoning, PFA designation, relatively close availability of public infrastructure. In this particular case, though I'm trying to be more general, Collector Road, those incentives and policy-driven decisions might very well encourage a property owner towards development that is permitted by the code and presumptively consistent with the comp plan.
That was a big question, so I'll try and break off the answer into, as I understand the question. You said generally, but also in this circumstances, which is what I looked at. This property is not zoned for development. It's not contiguous to the town. It has intervening property, which would have to come in as well. If the town annexed the property, it would have to be then rezoned because it does not have development zoning. In fact, it's got one of the most detrimental zonings that growth areas can have, and that's low density residential. If the owner were to come in and develop this with the very limited low density residential, that would clearly thwart this property as ever being a growth area because it wouldn't have a 30-year lifespan. But putting that aside for a second, under the town's own plan, and I'll cite you to the section in just a moment, if the property is annexed, it still needs to go through and get redesignated as a PFA. Has to meet the 3.5 acre limit, requirements, minimum density, and so on. So speaking to this property, you have those particulars. Generally speaking, your statement, Mr. Drummond, about, does it create incentives to develop the property? Yes, it does.
Okay. Thank you. And for all intents and purposes, approval and construction of the solar project puts the complete kibosh on any such incentives, either offered by the town or the county for the next 30 years, or if the settlement agreement is approved, 34 years.
There
Right.
would
Objection, he's mischaracterizing the settlement.
30 or 34 years. What am I mischaracterizing?
Why don't you refer the witness to the settlement agreement?
I only heard 34 years, so.
I said 30 or 34.
We're going to continue to adhere to the rule that we should really, if we're going to quote from documents, that we make those documents available to the witness. If we're asking him or her to confirm something in a document, it's fair to the witness.
It puts the kibosh on all those incentives and policy-driven decisions that might be that have already been put in place by the county and maybe be put in place by the town during the lifespan of this project.
I'm sorry, does the question go back to the settlement agreement, or I'm not sure?
No, I don't care if it lasts 15 years or 50 years. It puts the kibosh on all of those plans, incentives, policy-driven decisions. Right?
You could not develop, if this is used for a solar facility, assuming the whole property is used, you would not develop it as part of the growth area. You would go to alternative sites.
Those alternative sites are elsewhere around Chestertown.
I'm sorry, Mr. Drummond, I'm losing the first couple of words that come out of your mouth, and then I'm hearing the remainder. So I'm not sure if I hear that. I'm not trying to give you a hard time. I'm just not sure if I hear what you're asking.
Yes, you are. You always do. And are you referring to the other growth areas around Chestertown as alternatives?
I'm referring to, when I say alternatives for development, you have to look at the population projections that the county and town have put in their plans. And I'm using all of those in my assessment. The infill, the vacant lots, the growth areas, other growth areas designated around Chestertown, and the other growth areas for the county around other municipalities such as Rock Hall, Galena, Millington, and so on.
And have you examined the status of the properties in the other areas around Chestertown regarding their availability for residential, commercial, or mixed-use development? I'm specifically referring to preservation easements of one kind or another.
I've only examined the plans, and the plan does have a exhibit which I included in my testimony about, in regards to my direct, if you'll bear with me a second. It would be in my direct on attachment F, noted as page 89 of the Chestertown Comprehensive Plan, and it's entitled Map 3, Protected Lands, Chestertown Vicinity. So I just looked at that in regards to what other areas might be protected. And there seems to be a significant amount of lands protected around Chestertown. I think Greenbelt was referred to earlier, but the areas designated on the town's growth area map, which is shown as map 2 on page 86, do not appear to overlap, as best I could tell, with the protected lands map. So that's all I relied on. I did no separate analysis.
Didn't look in the land records to find mouth easements, forest conservation easements. I don't think there's any rural legacy easements in there, but those sorts of easements.
I did no additional analysis than review of the plans.
And you've also similarly not taken a look at the lands around the much smaller municipalities in Kent County to which you referred, that being Rock Hall, Betterton, or Galena.
No, I did not.
What the status of the wastewater treatment plants are in Rock Hall, Galena, and Betterton. That is, whether there's any capacity available at those plants.
That's in the plan. I don't recall what it was, and it's not part of my testimony, so I couldn't say.
Well, isn't it significant to know whether there's infrastructure available to build out around the towns as you are suggesting might be alternative sites for future growth?
My testimony consisted of evaluation of the various comprehensive plans, and whether or not this would, is particularly in regards to my direct, but then the rebuttal and the comments made by the town and the county, how this would thwart development opportunities. I did not do a complete assessment of a developability assessment, and nor is that really within my expertise to do that, because you'd be looking at wetlands, forest conservation, like you said, easements, forest conservation, steep slopes, critical areas, all those things. But the county looks at, and the towns look at those things as they're doing their land plans, and presumably, and I found in my experience, they don't designate areas for growth areas that they can't do development on.
Exactly. That's why this property is developed, has been designated as a PFA, and it's been rezoned to residential use in anticipation of annexation. So there may not be a 5-year holdback on rezoning after annexation. Do you agree with that, Mr. Stevens?
No, I don't. It does not have development density zoning. It has low density residential. Yes, you did.
I did. I did not. I said there won't be the 5-year holdback if it gets annexed.
Okay. I heard you say that it has development zoning. It doesn't have development zoning. And let me finish. In regards to the 5-year annexation hold, no one can tell you whether or not they're going to get the hold back. And I'll just give you an example as reference, and that's the Wheatland Farms that you and I worked on in Queen Anne's County. So you can't tell whether you're going to have the 5-year hold or not. It's purely political.
Know what the status of the capacity at Chestertown wastewater treatment plant is?
I can't say for sure. My recollection from analyzing what was in the master water and sewer plan is that there is some capacity. It's not at capacity.
Okay, Mr. Stevens, it was a pleasure. Thank you.
The pleasure was mine, Mr. Drummond. Have a good day.
Mr. Yeager, do you have any questions for this witness?
Yes, good afternoon, Mr. Stevens. As with Mr. Drummond, you and I have known each other, I think, about 30 years or maybe a little longer. To see you.
That's correct.
If you have been on this hearing for the last day, you can kind of tell that my voice leaves a little bit to be desired. So if I'm talking loud, to compensate for that, I'm not yelling at anybody. It's just because of the voice being kind of lost.
Quite all right.
Now, Mr. Stevens, with respect to infill lots, I guess you are aware, and I think you say this, and I'm sorry, I was reading your testimony, and I had the section up that I wanted to quote from, but I seem to have turned the page. But I think you would agree with me, and I think you noted this when Mr. Drummond was questioning you, that with respect to existing lots in the county and in the town, there are lots that may not be able to be developed because they aren't able to perk or meet other environmental or health department or regulatory criteria. Would you agree with that?
I think any lots of vacant parcels in the town would have sewer available to them, so they wouldn't have to perk. I did not do, as I said and testified, an analysis for each of these lots. I relied on the Chestertown plan and the section called infill development capacity, where it appears that the staff and the consultant who drafted this plan did at least a portion of that analysis that you're just talking about for the 25 vacant lots, and their results are right in the plan, and I attached a copy of it to my testimony. But yes, there's always some development prohibitions on any piece of property, just about.
Right. And I'll try to separate it out, because I agree with your point that it's different in the town, because for a lot to be created in the town, presumably there would have to be a water sewer allocation. And I take it you are familiar. You lived in this area at least on a part-time basis for many years. So you are familiar with Chestertown, and you would agree with me that there are what I would call co-owned lots, where you have a lot that is owned. It's an unapproved lot, but it's owned by the neighboring lot owner that has an approved lot.
I would presume so. I don't know for sure as a fact, and I've looked at it, but that's not untypical.
Right. And from a visual inspection, those lots would look like an extension of the yard from the lot where the home is. Is that fair to say?
Yes.
And the value of those lots would be to those homeowners that live adjacent to the lots to have a yard or open space. Would you agree with that? That they may be willing to pay more of a premium for those lots in order to maintain that extra yard or that open space or buffer?
Yeah, that seems reasonable, yes.
And I guess it would not surprise you that I am the owner of one of those. My wife and I are the owner of one of those lots for that very same reason.
Doesn't surprise me.
Now, with respect to the lots in the county, you are aware that there are lots that were created in the county years before today's current health department and environmental regulatory environment.
Yes.
And there are lots of record in the county that if you would attempt to create those lots today on that same land, chances are, given the regulatory requirements, those lots would not be able to be created today. Would you agree with that?
Yes, I do. But as I testified earlier, the county accounted for some of that, at least in their plan itself, when they made that determination of the 3,761 lots available. They said, although many of these parcels may not meet current health department and zoning standards preventing their development, many of these will be able to meet these requirements. And the title of this section is Subdivision Activity, the number of existing undeveloped lots in the county that could satisfy projected growth for more than 30 years. So I'm relying on that language in terms of my opinion. The other language that I just need to go back to in regards to the town itself and these vacant lots, which I know you have, Mr. Yeager, and others in town do, is that the 25 vacant parcels does not consist of these small lots next to or part of somebody else's home. There's a listing of what they are and what their uses are currently. And then the town also mentions your type of property in this plan, Mr. Yeager. It says at the bottom that they would anticipate that there are another 110 small lots in the town that could be developed at the bottom of that page 82, table 3. That's where I might presume a lot like yours would be accounted for. But in the potential infill lots, I believe they've excluded your type of lot that you were referring to.
Now, with respect to the lots in the county, I guess you're aware of the tax sale process, correct?
I do not do a lot of tax sale practice. I'm generally aware of it, but not a great deal.
And
only clearing title after a tax sale. That's about all that I've done.
That seeing that it's not unusual for some of these lots that are very challenged. I don't want to use the word unbuildable because somebody said to me once there's no such thing as a quote unbuildable lot, but a lot that is highly unlikely to be built upon. Are you aware that it's not unusual for some of these lots in the areas of the county to go into tax sale and not to have buyers at tax sale?
I honestly couldn't say, Mr. Yeager, one way or another. I've seen it happen where these vacant lots have gone for sale, sometimes purchased, but I'm not intimately involved in that type of practice.
Okay. Now, Mr. Stevens, as part of your practice in representing developers, you have, in representing clients, taken a look at zoning codes. I take it you do that on a regular basis.
I'm sorry, I missed just a word or two in the middle. Could you repeat it, please?
Sure. And as a regular portion of your practice, you represent developers or landowners that have proposed projects, right? Fair to say.
Yes.
Okay. And as part of your representation, is it fair to say that on a regular basis, you review and analyze zoning codes and land use ordinances to see if your client's proposed developments would be allowed or allowable under a current zoning code?
Yes.
And as part of that, you also look to determine whether or not a text amendment may be required or advisable to accommodate the project.
Yes,
And I take it in your practice that you have drafted many, many text amendments for this purpose over the years, over the last 25 years.
I have drafted many text amendments to various codes, including zoning codes, particularly zoning codes.
Right. And is it fair to say that it's not always your first draft of the text amendment that is the one that is ultimately passed and approved by the time you get through the planning commission and then the governing body, whether that is the county commissioners, county council, town council, et cetera?
I would say that at least 50% of the time in working with staff and with the various commissions and interest groups other than staff and, citizens, so on, that from the time I file an amendment to a zoning text to the time that same amendment through the same process is adopted does change some in probably 50% or more of the cases.
And it's not unusual that if you propose an amendment and it is not being looked at favorably by a planning commission or a town council or a county commission, it's not unusual for you to reach out and have conversations with officials, staff, attorneys, and representatives of the governing body to try to come up with amended language or alternative language in order to find something that may be acceptable. That fair to say?
Yes, sometimes I do. Not every time, but sometimes I do. Yes.
So let's say you propose something and for whatever reason at a planning commission level or a county council, town council, county commission level, it's not approved or it's given an unfavorable recommendation, you'll go back and try to address the concerns and come up with some language or some way that you can come up with something that may be acceptable to both your client and to the governing or approving body. That's something that you have done in the past, correct?
How it usually materializes is that we first hear from staff, and if staff expresses concerns and makes suggestions, sometimes they do, sometimes they don't. In this instance, I don't believe there was any done with the amendment that we provided. We will then try to tweak it to address those. Or the amendment might include things that we've heard in the past. For example, in this amendment, it did include additional buffering. I'm speaking to the amendment that's part of the record as my direct testimony, and will include, buffering, additional buffering requirements and things of that nature. When we get to the planning commission level, my experience has generally been that either the planning commission or staff has particular concerns that may or may not be able to be addressed. In this instance, there were no concerns expressed that when I took this to the planning commission, except for the unanimous recommendation of denial of the amendment. No changes were made. I don't think that any could have been made that would have addressed the underlying concern. And when it went to the county council, county commissioners, it ended up being the same. But so I didn't end up in a back and forth in this one.
So in this particular case, coming out of the planning commission, there was an unfavorable recommendation to the text amendment as read.
There was an unfavorable recommendation, yes, to the text amendment. You can say as written. On my experience in taking these through was that I wasn't going to be able to tweak any of the language or the provisions.
Yes or no question, Mr. Stevens. That's, my question was a yes or no question. I think that you answered that the planning commission gave an unfavorable recommendation. And after that, you didn't seek to withdraw the amendment or amend the amendment, come up with additional language. And I think it's also, for whatever reason, fair to say that you didn't contact staff or the planning commission and say, Is there something that I can do to change this or to resubmit or to add something? I'm not asking you the reasons, but I'm just saying this, that none of that occurred here. Is that correct?
Objection.
I heard the witness say that there was no back and forth in this case because the unfavorable recommendation, in his opinion, didn't allow for anything that would appease the, there was a no to the text amendment, and there was nothing that could be done to change that. Did I get that wrong, Mr. Stevens?
No, you did not, Your Honor. It was my assessment that a unanimous negative recommendation, there was no sense in trying to go back and do something different.
Okay, so I think that answers the question and takes care of your objection, Mr. Bugelmans.
Yes, Your Honor.
Thank you.
And
Next.
Mr. Stevens, so you made the decision after the Planning Commission and receiving the unfavorable recommendation not to withdraw the amendment. And you also made the decision not to seek to tweak or amend or contact staff, attorneys, officials to see if there could be anything done to make the amendment more favorable or acceptable.
Objection.
I'm not asking you the reason. I just want to confirm that you made the decision, or your client made the decision, I guess you're representing your client, that there was a decision made. Now, upon getting that.
That's a different question. Your first question, he already answered no to. Now you're asking if a decision was made, and you're talking about his client. That's a new question.
Okay. The decision was made not to withdraw and not to seek input to try to amend, tweak, or change. And what I just want to confirm that the fact that none of this was done wasn't out of your lack of knowledge or your negligence or anything like that, that this was an intentional decision made upon getting that unfavorable report or recommendation out of planning, not to withdraw and not to attempt to amend.
Objection.
What's the basis, Mr. Bugelman?
It's
compound 3 or 4 different
questions.
It is a compound question and 3 or 4 different questions. But
out. I did that in the intro. I
think Mr. Stevens can try to answer, and to the extent he can't, he can say he can't. He's pretty astute.
I just want to, I agree, but the basis for my objection is we're getting close to attorney-client privileged information. It's a fine line because he's obviously being offered here to talk about this process, but his questions are going to discussions that Mr. Stevens had with a client when he was their attorney. So that's my concern.
No, I understand. But when I said that Mr. Stevens is astute, I'm expecting him to indicate when he can't talk about a decision that was made.
Right. And one of the argument of the applicant, as I see it, is one that they made attempts to work with the county and to show some deference to the county's zoning law. And so I think it's a fair question as to the extent of that and the decisions that they made in that. And that's all on the table for this hearing. Anyway, Mr. Stevens, I asked you if you can remember the question, please answer as best you can. I can try to separate it out a little bit if you need, but why don't you go ahead and take a stab at it first?
There were several questions there, and I'm not trying to be evasive because to the extent that I don't edge close to attorney-client privilege, I'm happy to answer it to the extent that I can. We did not, and the client did not decide or decided not to pull the amendment. The amendment received a unanimous negative recommendation from the Planning Commission without any indication that there'd be a approvable form of the amendment. It was simply that That wasn't going to be permitted in that zoning district, the uses in those zoning districts. The final say is the county commissioners. And I've seen county commissioners do things that have gone up on a different recommendation. We were going to see the amendment through, and the client did not believe, in my estimation, that there was any real material opportunity to make changes. So they wanted to see it through, and hoped that the commissioners would act differently than the planning commission. I hope that answers your question.
I think he's answered your question.
All right.
Do you have another question?
No, Your Honor, thank you.
Are you finished then with this witness?
Yes.
Mr. Hicks?
Thank you, Your Honor. Excuse me. Good afternoon, Mr. Stevens. How are you?
Good, thank you. And you?
Good. My name is Jesse Hicks. I'm with the town of Chestertown. Some brief questions. I want to start, Mr. Drummond touched on it a bit, but you indicated that this area, the Clark Farm, a portion of that has been designated a priority funding area, correct?
Yes, by the county.
As well as the town?
Well, the town plan, and as the priority funding areas work, it's in the county priority funding area. If it's annexed into the town, it has to reapply once it's in the town and be redesignated according to the town's comprehensive plan.
Well, let me stop you for a second. Because you mentioned the comprehensive plan, the town of Chestertown does designate it within their comprehensive plan a priority funding area, though, correct?
They show a portion of it, as I indicated before, not the whole piece, approximately 200 of the 500 acres. They show in a priority funding area. Whether that's, I can't say whether that's simply a restatement of what's in the county's plan. I'd have to go back and look closer, or whether, but it's not a town priority funding area because it's not in the town yet.
So essentially, they can't designate it priority funding area because it's technically not theirs.
That's correct. And when it's if it's annexed, they have to reapply for priority funding area designation, as I understand.
Okay. But as far as you know, that the town does intend to do all of that pursuant to their comprehensive plan.
I don't know that at all, Mr. Hicks. I only know what's designated in the plan. I can't say what would happen if a development proposal came before the town that would include annexation.
Assuming annexation occurs, assuming town of Chestertown stays consistent with their comprehensive plan, based on their comprehensive plan, they would be designating that a priority funding area as consistent with what they state in their comprehensive plan.
It would be rezoned first to a zoning designation that's allowed in a priority funding area. The zoning it has now is too low density to allow in a priority funding area. So they'd have to go through annexation, rezoning, county approval of the rezoning for that 5-year hold period, redesignation as a priority funding area. Yes.
Sorry, for some reason my computer gives me double vision. In the comprehensive plan for the town of Chestertown, it does indicate that this area is a priority for future growth, correct?
Which plan are you referring to? I'm sorry. Did you say Chestertown or Kent County?
Town of Chestertown, sticking with the town of Chestertown.
Under the town's plan, this is one of the areas, this property is noted as part of the growth area for the town, yes.
And the town indicates in their comprehensive plan 4 different planning areas, correct?
Yes.
5, excuse me.
Whatever is on the maps I attach, yes, 4 or 5.
I'm looking at it. See if I can bring it up in your exhibit. I was looking at it actually in the comprehensive plan. I am looking at it's page 27 of the comprehensive plan. That's what it's listed as in your exhibit.
Was page 20 in my testimony, Mr. Hicks?
No, it's your exhibit, attachment F.
I have an exhibit which shows comprehensive plan, planning boundary, and it shows the planning boundary. It's page 27. It is a aerial photograph, and it shows 5 different planning areas indicated with compass symbols, i.e. southeast, northeast, which the clock farm is in a portion of, north, northwest, and southwest. There is also in the town comprehensive plan a description of each of those areas, which I cite part of. And then I also include, bear with me one second.
Mm-hmm.
There is on page 87 of the comprehensive plan, which is in my direct testimony. There is a listing of the tracks, the larger tracks that they feel are developable within, that the town feels and have designated this developable within that planning area. You can see them listed as deep tracks, northeast, Clock Farm individually listed, Route 20 Gateway Parcel, upriver extension area, Crestview, and Osmond. And that those areas are designated that accounts for, and they give an estimated number of units that could be supported in those areas. Right. So what my answer to your question is that it has the 5 planning areas, but then it has a breakdown of properties in those areas. I'm sorry.
Correct. And you mentioned it, you got ahead of me a little bit, but you mentioned in the comprehensive plan, there is actually a breakdown of each planning area by the county.
It breaks down some of the properties that are suitable, or at least according to the comp plan, projected growth in residential units through potential annexations. That's on page 87. Yes.
Not that. Immediately following the map with the compass designations, you indicated that there is a text breakdown of each planning area.
What page are you referring to?
It would, of the comprehensive plan.
Yes.
32.
Okay. I don't know if let's just make sure.
You included a short excerpt, specifically the northeast planning area.
Yes, I have it.
Okay. And I'm going to direct your attention to the second paragraph for the northeast planning area, that first sentence. Is it
yes.
true that the town says that if and when annexation occurs, the northeast planning area is most likely a place where it will happen?
Yes.
Okay. Do you recall them breaking down the other planning areas?
There's on page, the following pages talk about each of the other planning areas. I only cited the northeast planning area, but on pages 32 and the ones to follow, I believe it does talk about the other planning areas. I don't think I included it in my testimony.
Do you recall them?
Vaguely.
Your Honor, if I may, I did cite I cut an excerpt from the comprehensive plan that I was going to use as an exhibit. If I may forward that, I forwarded to the entirety of the case, but if I may forward it again for Mr. Stevens' reference.
Mr. Bugelmans, can you forward Mr. Hicks's email with his exhibits to your client?
I am looking through my email now, Your Honor, and I don't think I received Mr. Hicks' email.
Would have been yesterday at about 9 o'clock in the morning.
What I received is entitled Commissioner's Resolution.
And there should be a second attachment that says Land Use Comprehensive Plan excerpt.
Right.
Oh,
Right.
yep, I have that too.
Okay, I see it, so I'll do what I did before, where I will make sure everyone's included. And I will send it to Mr. Stevens.
Thank you, Mr. Bugelman.
And Mr. Hicks, you're going to be referring to the land use comprehensive plan excerpt?
Yes. And I'll lay the foundation through Mr. Stevens.
Okay. I've sent the email. It may take a few seconds to land in Mr. Stevens' inbox.
Thank you. Mr. Bugelmans, I did ask the parties to share exhibits with their client, and these emails, I know they came in late, close to the beginning of the hearing Monday, but they should have been shared with the witnesses.
I apologize, Your Honor. I missed this one.
Mr. Stevens, just give me a heads up when you get it. I can lay a little foundation for it now. So as we discussed within the comprehensive plan of the 5 planning areas, the town did do a breakdown of each planning area, correct?
I believe it had a discussion points of each of the planning areas, yes.
And in your exhibit, it only included the Northeast planning area, which is the planning area at issue in this matter.
That's correct.
And I'm referring to it as a planning area because that's how it's referred to in the comprehensive plan.
I have the exhibit.
Okay. And it looks like I have pages 27 through 33 in succession.
There are several pages to what was sent, but they're not numbered.
It should be the second exhibit, should be land use comprehensive.
Yeah, yes, I have that. I'm just saying that there was the maps were not numbered that I could see. So
The pages are numbered, Mr.
On the
Stevens.
bottom,
pages, I have page 32,
Mhm.
as you referenced, which I included, and then page 33.
Repeat that, you only have page 32 and 33?
Thir 32 and 33, but preceding those pages, I have several maps. Oh, wait, sorry. I'm sorry. I thought you're looking for pages after. So I want to go through what I have. You can tell me if it's accurate. There's 7 pages. First one is the comprehensive plan boundary.
And the bottom left of that, there's a page 20.
After that, I have land use in Kent County planning areas, Southwest planning area, Northwest planning area, North planning area, page 28. Current land use map, future land use in town map, future land use outside of town map, and then page 32, Northeast planning area and Southeast planning area running over into page 33. That's what I have.
So as you have reviewed the Kent County Comprehensive Plan and you have included an excerpt of this specific part, does this accurately reflect the town comprehensive plan, pages 27 through 33 to the best of your knowledge?
Yes.
And Your Honor, my familiarity with the commissioner, should I move to admit this as an exhibit at this point if we're going to be referring to it?
You can mark it for identification now.
Okay.
You don't need to move it in through this witness if you have your own witness to do so, but you can try. I think he has testified that he's familiar with it. So
Well, I would mark and move to admit then. It would be, I guess, Town of Chestertown's Exhibit 1.
So marked. And then any objections to it coming into evidence as is the excerpt? Okay, hearing no objection, Town of Chestertown Exhibit 1 is admitted into the record.
Thank you, Your Honor. Just refer quickly to each of these. Southwest planning area, second paragraph, it says that other than infill, no new residential development is anticipated or desired in this planning area as it is outside of the Kent County priority funding area.
Yes, okay. I'm sorry, I didn't mute.
Yeah, okay. And then the Northwest planning area, the last sentence in that paragraph says the existing development pattern in this planning area makes it difficult to extend roads and create the cohesive neighborhoods the town wants.
Okay, the last sentence does say that.
Okay. North planning area, the last sentence, no additional development is projected or desired in this area.
Yes, I see that in the last sentence.
Basically, what I'm getting at is these breakdowns, which you did not include in your exhibit, do include reasons why the town does not intend to annex these additional planning areas. Save some time.
I don't know that that included all of the additional planning areas. As I indicated before, my testimony was based on what the town has in its plan, where it indicates in the table that I referenced, table 5, projected growth from the planning area. So I assume
Right.
that if the town has something such as the clock farm, which it says here is under conservation easement or something of that nature, it's not included in that table 5, and I don't see it included in the table 5. I'm not referring to the clock farm, the big clock farm, Your Honor. There's another farm, as you can see, out on the north, I think, northwest planning area shown as clock farm.
Right.
So I went by, in my analysis and to formulate my assessment, I went by looking at that table. I really didn't go beyond and try to evaluate
That's
what
fine.
might be under
That's fine.
PSC.
I'm just establishing that there are other planning areas that were not included in your exhibit.
That's correct.
Okay. As far as this comprehensive plan, do you recall when it was created?
I believe it's 2015.
Okay, so that predates the application for the CPCN.
I believe so, yes. I think it was
Okay.
18 or 19 that the application went in.
Correct. So one of your arguments you've made for the land use is that Chestertown has what's known as infill lots, correct?
Correct.
If I can, I'm scrolling through your exhibits. I believe you said that there's approximately 880 infill lots that would be available to the town.
Whatever is in the table and in the infill lot development section I quoted in my testimony of the infill lot development section of the town's comprehensive plan from 2015. So I believe there was 880, and then it also accounted for another 110 anticipated lots, getting to 990, I think.
Correct. And that's page 82. Do you know when
Yes.
these statistics were compiled? Obviously before 2015, but do you have any type of exact timeline?
I am not sure. There was some reference in some of the. I'm not sure. No, I don't know when they were compiled.
Okay, that's fine. And then we're talking about the infill in relation to population growth on page 80. Projected growth, population projections for Chestertown between 2010 and 2030. Do you see that?
Yes.
Okay. would you agree that those population projections obviously were established prior to 2015?
I don't, well, it says source 2004, Chestertown Comprehensive Plan, and URS Corporation 2009. So I can go by the source in the comp plan. Again, I relied on the numbers in the plan.
That's fine. And so 2009 was when those numbers were compiled, we can safely say.
That according to the plan, yes.
And now we're 2021, so those numbers could be drastically different, correct? You're muted, sir.
I'm sorry, I'm getting a bit confused as the day's going on to mute and unmute. My apologies.
Listen, I completely understand. You're fine.
Based on other testimony provided and attachments, it seems to be that there's some census data that indicates that Chestertown actually lost some population. I find that the data information about population projections, because of their age and also because of some very large projections which didn't seem to have panned out, to be, you know, it's difficult when you do plans during interim years. The way I look at it is, if the jurisdiction determines that this is valid enough to put in the plan, I think that's what I rely on.
Okay. You included it as an exhibit in your direct testimony, though, correct? Or your supplemental direct testimony?
Yes.
What I'm looking at right now. Okay. So you indicate then that your opinions or your statements within your testimony was based upon using these numbers for your conclusions.
Yes, my conclusions were in regards to the comprehensive plans of Chestertown and Kent County.
Okay. And again, just referring to the town of Chestertown for right now, I'm not going to get too much into Kent County. You would also agree that because we don't have a source for it, but the infill numbers could be different or drastically different than they were as they were compiled in a 2015 comprehensive plan.
I can't agree or disagree with that. I don't know.
Is it a possibility?
It's a possibility they're the same. It's a possibility that they're less. There's a possibility that there could be a little more if there was some redevelopment done where buildings were taken down and land laid vacant for some time. Or
right.
So.
And as this has been pending for approximately 3-4 years, you haven't done any additional research into whether or not there's more or less infill lots available to the town of Chestertown.
From my assessment about comprehensive plan for both Chestertown and Kent County, relied solely on the plans themselves.
Great. Thank you. As well, back to page 80, talking about the population growth. These are population projections for Chestertown between 2010 and 2030, correct?
Yes.
And as we sit here today, the potential for the solar farm, the lease is it's 4 years to complete construction and then additional 26. We're talking about 30 years, correct?
Yes, I understand that.
Okay, so that actually goes all the way to 2050, 2051, correct?
2050 thereabouts, I assume.
Correct. So we really have no knowledge about the population growth or population projections for 2/3 of this solar farm lease, correct?
There are none in the plan, no.
Correct. And again, the only thing you relied on were the numbers in the plan.
That's correct.
Okay. And based on your experience, just overall, comprehensive plans are completed every 10 years, correct?
Yes, or longer. They're supposed to be completed every 10 years under state law directive, but it often takes longer. So it often ends up being 12 or 15 years, is my experience in most jurisdictions.
Let me ask you this. So the objectives for the town in their comprehensive plan is to low density residential property in that Clark Farm area, part of that Clark Farm area, correct?
I'm sorry, I don't understand the question. The objective for the town is to have
Yes.
low density in the Clark Farm area. Is that what you're asking me, if that's my assessment?
I kind of combined some things. We'll break it down. In the comprehensive plan, the town indicates that they have a potential to develop a portion of that Clark Farm for potential population growth, correct?
The Clark Farm is designated as part of a growth area for the town of the several ones that you referenced. The Clark Farm, under the estimated future residential units for the county under Table 5, shows it to possibly accommodate 1,100 additional units into the town of Chestertown, with another, 12 or 1,300 in the other growth areas, 1,300 or so in the other growth areas, dwelling units. I don't know that that's low density. Well, but, we can get into that dialogue about PFAs and what the density has to be. So you got to be a little more specific with me, because I'm not sure I'm following what you'd like me to answer.
I apologize. I shouldn't have said low density. The question was the town of Chestertown. It's an objective of theirs within the town comprehensive plan that, based upon population growth, and I'm just repeating the question, so I don't need your answer because you answered it, but population growth would be to annex a portion of the Clark Farm for residential development.
Well, I think according to the plan, comprehensive plan for the town of Chestertown, their goal is to annex all of the available lands for development around the town, ultimately, and then creating a green belt around the town. When you read the whole plan, some of the sections I'm not citing here, but I did look at the whole plan, and that their plan is to allow development on I think, except for the sensitive areas and those that are undeveloped of the Clark Farm, allow it on the entirety of the Clark Farm and annex it, and annex the other developable farms in the growth area. And they say that that won't happen in the plan itself. And I cited the section for some 30 years. And then they even reference, which I didn't cite, I don't think, they even reference a possible 50-year ultimate build out before they actually create this green belt. But that's the ultimate goal of the town plan, as I read it, to have this development, these development areas infill, and then create a green belt around the town, and let that take place over the next several decades.
And you're manipulating my question a little bit, but the question was about an objective for this Clark Farm
is to annex it and to eventually annex it and eventually allow residential development on it. That's my understanding.
Okay. But not the full Clark Farm, correct? There's a portion of it that they don't have any anticipation of annexation.
I'm not aware of that. You'd have to point me to a plan that shows less than the entire Clark Farm in the growth area. I didn't see it unless I missed it. I think only a portion of it is in a priority funding area, and that would be the 200 or so acres closest to the town is in the county's priority funding area, which, if annexed, would have to go into the town's priority funding area and be redesignated. But the entirety of the Clark Farm is shown in the growth area for the town plan.
But the inclusion, well, fine. If the it would indicate, if that area is a priority funding area, that would be the only area that would receive state funds for development, correct? Under the priority funding area designation?
No, not at all. Lots of areas that are designated in town plans, municipal plans, as growth areas are not even shown as a priority funding area in the plans until they're annexed. Once you get annexed, you apply to the state for priority funding and you show them proof that you've met the criteria. And then the state, after they do a clearinghouse through state planning and so on, Department of Environment, they then come back and they say, yes, we grant you that designation. Then they can use state-funded infrastructure to extend out there. Whether or not a portion or none of the Clark Farm is priority funding area today has really no bearing on what it would be after annexation. it's the plan designation that has bearing on whether it can be annexed and rezoned.
You indicate that the population growth might not be enough to require this type of annexation, correct?
Well, what I indicate is when you look at the availability of the vacant lots, county lots, other areas in the growth area, according to the town's plans, that can be annexed, and the county's growth rate. And I have to stress that, the town has various growth rates and they only go out to 2030, but the county's plan, and I cite it in my testimony, has their growth projections going out to 2040.
Mr. Stevens,
let me finish.
Mr. Stevens, we're getting outside of the question. All I'm asking is, you have indicated that based on population growth of the town of Chestertown, with the infill parcels, that annexation of the Clark Farm won't be necessary for some time. It's yes or no?
Well, wait a minute. Is that did he correctly restate your testimony?
No, he didn't. I looked at overall, both plans combined, and my testimony is based on growth areas and development in both areas. I'm not saying that the town infill development and the other areas provided for development in the town plan could not accommodate growth for the next 30 years around the town. They may very well be able to, or which is my general feeling, but I don't have population projections for the town that go out that far. What I'm saying is that that when you look at the totality of all the land available for development, and I look at, and I can project out further because the county plan does, and you look at the county plan and what they expect for growth, it more than accommodates that time period. That's what I'm saying.
Is it possible for the town to annex only a portion of the Clark Farm and still be in line with the objectives of their comprehensive plan?
The town could, and a developer could come in and purport to annex just a portion and ask for the town to consider that, and it may do that. It would not be it would not be illegal to do that, by any stretch, and it probably wouldn't be necessarily inconsistent with its plans because it could later on go back and annex some more.
Correct. So it would kind of fit the objectives of both parties if that land was split, let's say at where the projected bypass is.
I don't know what you mean by objectives of both parties, and I didn't have any testimony about the bypass, I don't believe.
Court indulgence. I thought I saw a map in your exhibits that indicated the bypass.
Yeah, one of the maps did show the bypass, but I don't think I referenced or spoke to it at all.
I don't believe any other questions this time.
Mr. Albert, do you have questions for this witness?
Your Honor, no, I do not. Thank you for asking.
Any redirect, Mr. Bugelmans?
I have no redirect, Your Honor.
Mr. Stevens, you were
Yes.
giving an answer to Mr. Drummond, and I think he cut you off, and I wanted to understand what you were saying. So in my notes, even though it's not stated in the intent statement, something about a special exception might provide. He was asking you about whether the utility scale solar was presumptively inconsistent with the zoning ordinance and zoning maps. And you said something about, even though it's not stated in the intent statement, there were other places to look, and something about a special exception. Do you recall that line of questioning?
I do, Your Honor. I think Mr. Drummond was asking me if because the intent statement doesn't recognize anything such as utility scale solar, isn't that presumptively inconsistent with the zoning and the plan? And my response was that intent statements are general in nature. And many times, and in many ordinances, and you can probably pick through Kent County zoning ordinance as well, you will find uses that one would think don't fit at all or even squarely with the intent statement that are allowed. Sometimes they're conditional uses or special exceptions. That was my answer. So for example, in the ag district, you find provisions that allow for residential development. That might be inconsistent with agricultural uses. In the rural residential district, you might find provisions that allow for agricultural implement dealers and things like that. That was the only point that I was making, Your Honor.
And then later, you said something about a low density residential area not having a 30-year lifespan. Do you recall that?
Yeah, I do, Your Honor.
Can you explain that to me?
Yes. What I was indicating through that is that the Clark Farm right now has no sewer and water. It's not in the 20-year sewer and water planning period. It's not in the town. It's not adjacent to the town, and it's zoned low density residential. If somebody came in and developed under that use, it would thwart the overall growth plans for the town because it would be in large lots, as many as they could get under the zoning or under the Sustainable Growth Act, which limits the number of lots on septic systems. And that would be permanent. And that use, in my estimation, if the owner chose to go that direction, would be more detrimental to the town's plan because it wouldn't have a 30-year lifespan. It would be there until I don't know how long. That was my point with that testimony.
Thank you. Then you said that the priority funding area is not zoned for a priority funding area now. But so help me out. The Clark Farm is in a priority funding area, but it's not zoned for a priority funding area?
Yes, the county's plan shows the 200-acre portion of the Clark Farm as PFA, priority funding area. The priority funding area requirements, if annexed, and they request a new designation of priority funding area, because according to the plan, they have to come in as the town and say, we're going to ask for priority funding area, requires minimum densities of 3.5 units per acre. So you have to have density under the priority funding law to be.
So how did they get it for what exists now?
I'm not sure, Your Honor. I'm not sure why part of it is designated priority funding. Perhaps they were indicating that they would cluster a lot of the development at that density, or allowed to cluster and reach those higher densities. I'm not sure why they would designate a property. Usually, in my experience, a property that is in a adjacent or near a town that's in the growth area is not a priority funding area till it comes into the town. And then they request it, and it becomes a priority, and rezone it and request it.
Thank you. Any questions based on my questions?
No questions, Your Honor.
Okay. Thank you, Mr. Stevens, for your testimony.
Your Honor, I do have a couple of questions in light
Based
of
on my questions?
Yes, ma'am.
Okay, please proceed.
Thank you. Mr. Stevens, no particular mystery that the property is that which is designated as PFA. If someone were to propose a development and take advantage of the PFA designation, property would have to be rezoned. Do you agree with that, to up the densities?
I think so, yes. I believe so, yes.
And certainly the county would have that option available to it.
It would be the town if it was annexed, not the county, except for the 5-year hold.
That's in the county. Say it remains in the county. The county would have that option available to it. Correct? As either part of a comprehensive update or arguably under some sort of a mistake or change argument, correct?
No, only if the town were willing to extend facilities there without it being within the town municipal boundaries, which is pretty unusual and unique.
And the town certainly will, and if it annexes it and seeks a PFA designation, the town zoning will have to be different than the county zoning, but not dramatically so to get to 3.5 units per acre.
I would agree that if it's annexed and to get to PFA status, it would need some different zoning district, some residential or mixed use district under the town's code.
Don't you think that what the county has done in its comprehensive plan is telegraphed to both the town, the State Department of Planning, and in the event of annexation, this 200 acres should be so designated following annexation? Isn't that the point of the county's PFA designation?
That'd be supposition on my part. I just don't know, Mr. Drummond. Is anybody speaking? I'm not hearing anything.
I'm not hearing anything either. I'm not sure what happened to Mr. Drummond. Let's give him a minute to see if he comes back.
I indicated that I was done.
No one heard you say that, Mr. Drummond. Okay. Thank you, Mr. Stevens.
I do want to point out, Your Honor, before we excuse the witness, that I previously indicated that perhaps Mr. Stevens could speak to the border of the town and the substation. I just wanted to raise that before we excused him if we wanted to ask him about it, but I don't have any questions for him. I just
Okay. I mean, I can ask him. I agreed with you that perhaps the town was a better source, but I'll ask him. Mr. Stevens, are you familiar with where the boundary of the town of Chestertown is in relation to the Chestertown substation?
Your Honor, I agree with you that the town is the best source because they have a meets and bounds description of their boundary. However, I reviewed, after I heard that discussion, I reviewed the town's zoning map. And according to its zoning map, it is not within the boundary as best as I could tell from the town's zoning map. I also looked at the county's property viewer program, which allows you to hone in on properties. It didn't give me a great deal of information. Again, it gave the appearance that it's within the county and not within the town, but I cannot testify that that is a for certain. And I agree with you, Your Honor, that you can get that information directly from the town.
Okay, my last question for you though is, in your experience, are zoning maps at times not as accurate as a meets and bounds type map?
I have seen zoning maps that have been inaccurate, not a great deal of them when they're produced by the jurisdiction, but yes, they are inaccurate, especially for the counties because they cover such large areas and they usually use tax maps as the base. That's what they used to do. Now it's probably different with GIS and much more accurate now with GIS. Yes, it's not unusual that there's inaccuracies between tax mapping, zoning, and Google Earth.
Okay, so what I want from either the town or perhaps the county is a meets and bounds map. Is that your testimony?
The town should have that as part of their charter. They should have meets and bounds description of their boundaries. I believe as part of their charter, they're required to.
Okay, thank you.
Thank you, Your Honor. Am I excused, or do you want me to stick around?
I'm just waiting a second to see if anyone's gonna unmute themselves and jump in.
I am.
Mr. Hicks?
I was able to get a meets and bounds. It's not a map, but I can forward that over.
That would
My
be,
discussion is that it is not included in the town of Chestertown.
okay, that's helpful. And if you can forward that, that's great. And we can probably discuss that with Mayor Foster.
Yes, ma'am.
Thank you. Okay, then you are excused, Mr. Stevens. Thank you for your testimony.
Thank you, Your Honor, and I apologize for the technical difficulties. It seems no matter how much testing you do at the beginning, sometimes something pops up.
Understood.
Thank you.
I think we're going to take a 10-minute recess before we come back. I think we're up to Mr. Sidzinski. Am I saying that correctly, Ms. McLemore?
Yes, Your Honor, you are. Also, I have a couple of housekeeping matters with regard to, I have a revised PPRP exhibit list that it's been corrected. I'm going to go ahead and send that out to everyone if that is okay.
That's fine. Mm-hmm.
Okay. And also in the header on the title page in the right-hand corner, it'll say PPRP exhibit, and then it'll have RS and a number. There are some instances where I would like to correct that number. It really has no, there's no meaning with regard to evidence. It's just housekeeping, making sure that we're referencing the correct document. If that's okay, I would like to go ahead and have that corrected too at the start. If not, I can do it with every document with Mr. Sidzinski if you'd like me to do that instead.
No, I think we can do it at the start as an administrative matter. When we come back at 3, Ms. McLemore, were you here earlier, and did you hear the discussion I had with Mr. Bugelmans about the limit of construction and the interconnection with the substation? And I believe he dropped the ball in your court when he said that in his experience it's PPRP's position that the point of interconnection is within the construction of a generating station.
Yes, Your Honor, I was here, and
Okay.
I believe that is correct. But if I could take that as a bench data request and let you know by the end of before the end of the hearing, that I would prefer that, just to make sure I'm not misstating.
Okay, but you understand exactly what my question is?
Yes.
Okay, we're gonna get the facts about where the Chestertown substation is from
Right.
witnesses, but I need the legal position with regard to section 7207E.
I understand. Yes, Your Honor.
Okay, yes, if you can submit that, I'd appreciate it before the post-hearing briefs for my preparation, but so as soon as you can get that to me, that'd be great.
All right.
Your
Thank
Honor,
you.
can I ask just clarification on the order of the next few? I know we've got PPRP's second witness coming on. Then what would be the order of the parties?
Then we would next have KCPA's witnesses, of which I believe there are 2, followed by Kent County's 3 witnesses, followed by Chestertown's 1 witness, and then staff has 1 witness.
Thank you.
KCPA has 3 witnesses.
3 witnesses, excuse me. KCPA has 3 witnesses. I don't know if we'll start one today. And so looking at Kent County and Chestertown anyway tomorrow, and hopefully staff tomorrow as well, so we can finish up
I
tomorrow.
think that was my question, confirming that we're not going to need the Kent County witnesses until tomorrow. Is that correct?
I think that's correct, yes.
Thank you.
And if you recall, we're starting at 9 a.m. tomorrow.
Yes.
Okay. All right. So we're going to take a break until 3 p.m. We're off the record.
It's
Mr. Court Reporter, are you ready?
Can you allow me 30 seconds to a minute?
30 seconds, yes. 30 minutes, no.
Okay, I got you. Hold on.
Let me know when you're ready, Doug.
You're on the record, Your Honor.
Thank you. We're back on the record in case number 9499. Ms. McLemore, you want to proceed with your revised exhibit list that you sent around? And correct me if I'm wrong, it looks like you are correcting typographical errors in the exhibit list, correct?
Your Honor, also, if you look at beginning with PPRP Exhibit 5, if you look at the end part of the title, it says PPRP Exhibit space RAS dash, and I corrected it to say 5.
Yes. Is that because that's what it was filed as?
Well, it was inaccurate in the filing. It should have been, that's to make sure we understand how many documents that Mr. Sistinsky is providing, and we made a mistake, and it's not.
You made a mistake when you originally filed it.
Right.
Okay.
So I'd like to go ahead and correct that if possible. Like I said, it has nothing to do with the actual evidence. It's just a
Mr. Albert, I'm muting you. Hopefully that takes care of the issue. No.
Apologies, I didn't mean to stay on.
Okay, does everyone understand these exhibits were all pre-filed in the docket, but with respect to PPRP Exhibit 5, it was labeled incorrectly. So it should be RAS-5 on the document that was filed.
Your
What's
Honor,
the, after that, when you have in red line title page and dash applicant?
I'm sorry, go ahead. I apologize.
What is that?
That's just further explanation because it's quite a long attachment, and I wanted just to make sure everybody understood what was included. It has nothing to do, although okay, so with regard to the correction about the PPRP exhibit, unfortunately, it goes from PPRP Exhibit 5 down through PPRP Exhibit 13.
The error that was made when originally filed.
Yes, Your Honor.
Okay.
So that would be the first thing. Do I need to go through them and state it, or can on the record so that everybody will know to change that on their title page?
I think as we go through, if you just say it again as a, reminder.
Okay.
Everyone has the exhibit list to refer to, but then when you introduce each exhibit as you're going to do and ask me to mark them, you'll repeat that and you'll have it corrected. And I think that'll work.
All right, thank you, Your Honor. There's one additional item. We inadvertently did not include the attachment to applicant's response PPRP DR 1-4. And what that is, I sent it this morning at 9:42 to the parties and you. And what it is MHT's second letter regarding the project. It came up yesterday, and so we hunted for it and made sure we had it available. If anyone has any objection, I don't need to include it, but I wanted to offer it if that would be helpful.
Okay, I recall vaguely this coming up, but I don't recall who was looking for it. Why don't we, you don't have this pre-marked is what you're saying, and this is not part of anything else?
Well, actually, it should have been a part of PPRP Exhibit 5, which is Attachment A to the PAR. It's responses to PPRP data request, and it's an attachment to PPRP DR 1-4. However, we did not include it. It was inadvertently left out.
So why don't we, do you think it makes sense to add a PPRP Exhibit 17?
If that's the best way to handle it, that's fine with me, Your Honor.
Okay, why don't we proceed that way? That way it'll be clear.
All right, thank you, Your Honor. Apologies for that.
Okay, are you wanting to mark any of these before you have Mr. Szydzinski on the stand?
I think it might be more efficient, but if anyone has a problem, I can do it whichever way you would like me to.
Well, the first exhibit you have is his direct testimony. So,
yeah, do you want me to go ahead and read them out loud and have them marked?
Yeah, why don't we do that?
Okay. Your Honor, if you could mark the direct testimony of Robert A. Szydzinski that filed on December 17, 2019 as PPRP Exhibit 1.
So marked.
If you could mark the secretarial letter also filed on December 17, 2019 as PPRP Exhibit 2.
So marked.
And the initial recommended license conditions, which also were filed on December 17, 2019 as PPRP Exhibit 3.
So marked.
And number PPRP Exhibit 4, the project assessment report, also filed on December 17, 2019 as PPRP Exhibit 4.
I'll mark it, but I have a question.
Okay.
Wasn't it, was it entitled draft?
Is it? I'm sorry. Yes, it may have. So typically we have in many instances, we used to publish all the PARs. And so it says draft on it because it is a draft until we publish it.
Okay, so I just want to make sure everyone is clear that there's not another document. So the one dated December 17, 2019 says draft, and that's the document you'd like labeled, or I'm sorry, marked as Exhibit 4, and it will be marked as PPRP Exhibit 4.
Thank you, Your Honor. Next, I have the attachment A, which is included as attachment A to the PPRP project assessment report draft. The responses to PPRP data request included are the applicant responses to DR1, PPRP DR2, PPRP DR3, Kent County responses to PPRP2, and KCPA responses to DR1. This was filed on December 17, 2019. If I could have that marked as PPRP Exhibit 5.
So marked.
And also, as we just indicated, the PPRP Exhibit RAS number should be changed to 5 on the title page. Next, we have,
Can you, I'm sorry. This was entitled RAS-5 applicant DR responses when you
yes,
sent it most recently. Did you already change it when you sent it out yesterday morning?
the, this morning, I just sent it out, Your Honor, right after, in the break. But
Okay, then I might have the wrong one pulled up. I have something that's already labeled. It's got your PRP exhibit with a underscore and then in parentheses RAS-5, but maybe I went ahead to the next one. In other words, I don't see something to correct.
oh, I sent one out a while ago. I'm sorry, I'm not understanding your question. I just sent
When you
out,
sent them out, were they already corrected in terms of the typographical error, changing just the number after the RAS?
when I sent out the exhibit list just now,
No,
they
no.
were,
When you sent around the exhibits themselves. No? Hang on. I'm sorry.
Your Honor, now I understand what you're saying. This morning when I sent out the Department of Planning second letter, July 17, 2019 letter, is that what you're talking about?
I'm going to pull it up a different way. Hang on a second. I saved your exhibits to a subdirectory under PPRP, but I'm going to go back to the docket because okay, so if you look at the docket under docket item number 45, which is when PPRP filed all of its original testimony, which one of these are you wanting to be marked as Exhibit 5?
The Appendix A data request responses, PSC case 9499, Morgnec Road Solar Project, and it's the Appendix A to the project assessment report. It was including into the PAR. I believe we had, given the size of things, I think we broke them out. If you would like me
Okay,
to
no,
keep it.
I have it. I'm looking at the docket, so I just
Okay.
pulled up from the docket Appendix A data request responses. That's like your cover page, right?
Yes, Your Honor.
Okay. I'm sorry. I don't mean to drag this out, but this doesn't have any designation with regard to RAS dash.
No, Your Honor, it does not, and it should have. And
Okay, so it should have had the entire designation that you're now changing?
the reason I'm changing it is when we start writing briefs, it's easier to reference the document if it's not included as a complete docket. So that's why I changed the exhibits and added more. If you do not want me to, I was trying to make it easier if it is more.
No, I think that, okay, I have attachment A as it was filed on December 17, 2019, as part of a bunch of documents that were filed that day. I think what gets confusing to me, I don't know if it gets confusing to anyone else, is the RAS dash number, because that doesn't end up relating to necessarily to the exhibits that get entered into the record. So I have attachment A. I trust everyone else does. It's in the docket. It will be marked as PPRP Exhibit 5.
Thank you, Your Honor.
You can go ahead to the next
The
one.
next document is the Appendix B, which is the glare analysis. It was included in the PAR as well. And that was filed on December the 17th, 2019 as well.
Okay, the glare analysis Exhibit B to the PAR will be marked as PPRP Exhibit 6.
Thank you, Your Honor. And for Exhibit 7, the reply testimony of Robert A. Zidzinski, also filed on March 23rd, 2020. If I could have that marked as PPRP Exhibit 7.
So marked.
And there, the number at the top should be changed from 4 to 7, the
Yes.
RAS-7. Next, I have the applicant's responses to DRs. It's PPRP RAS, the 5 should be changed to 8. And this includes the responses to DR4 and also the responses to Kent County DR2. This was filed on March 23rd, 2020. If I could have that marked as Exhibit 8.
So marked.
Next is the Kent County responses to PPRP DR2. If I could have the corrected PPRP Exhibit RAS-9. This was also filed on March 23rd, 2020. If I could have that marked as PPRP Exhibit 9.
So marked.
Next is the KCPA responses to PPRP DR1 and Kent County DR2. This has a header of PPRP Exhibit space RAS-7. If I could change that to RAS-10. This was filed on March 23rd, 2020. If I could have that marked as PPRP Exhibit 10.
So marked.
Next, Chestertown responses to PPRP DR1. If I could change the PPRP Exhibit RAS- to 11 and cross out 8. This was filed on March 23rd, 2020. I could have this marked as PPRP Exhibit 11.
So marked.
Next is the supplemental testimony of Robert A. Zidzinski. It also has a header PPRP Exhibit space RAS-4. If we could delete 4, cross out 4, and instead change that to 12. This was filed on October the 20th, 2021. If I could have that marked as PPRP Exhibit 12.
So marked.
Next, the revised recommended license conditions. 1-October 2021. This was filed on October 20, 2021. If I could first correct the PPRP Exhibit space RAS number to I apologize. If I could add the header PPRP Exhibit RAS-13 to that page. It did not include this when we filed it. I could include that on that page.
That's fine. I'm not sure it's necessary, but that's fine.
And PPRP Exhibit, if I could have that marked as PPRP Exhibit 13.
So marked.
And finally, the supplemental rebuttal testimony of Robert A. Zidzinski, with a header PPRP Exhibit space RAS. If I could change that to 14. This was filed on October the 29th, 2021. If I could have that marked as PPRP Exhibit 14.
So marked.
Thank you, Your Honor.
I'm sorry, for 13, it was filed, is that October 1st?
Right. Your Honor, that was the date of the settlement. These were included in the.
No, 10/20. I'm
settlement.
sorry. No, I see the date it was filed now, 10/20. I apologize.
Right. But the date of the actual revised conditions was the date of the proposed settlement.
Okay. Sorry about that. And then we entered into the record 15 and 16 yesterday, correct?
Yes, Your Honor.
And then with all of those attachments, correct?
Yes, Your Honor.
Okay, and then, so we're up to PPRP 17?
Yes, Your Honor.
Okay. And as we already discussed, that's the July 17, 2019 MHT letter.
Yes, Your Honor.
Will be marked as PPRP 17. Okay. Did you want to?
Yes, if we could call Robert A. Zudzinski to the stand for on behalf of PPRP.
Good afternoon, Master Zudzinski. Can you please raise your right hand? Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
And Ms. McLemore, can you provide an attestation for this witness, please?
Yes, Your Honor. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you. Please proceed.
Apologies. I was on mute. Mr. Zudzinski, could you please state your name and address?
Yes, Robert Szynski, last name is Sadzinski. Business address is 580 Taylor Ave, Annapolis, Maryland, 21401.
And what is your title?
It's acting director, Power Plant Research Program.
And you have before you a number of documents that that you are providing in the record today. Do you have one of them? The first one is the direct testimony. It's entitled Direct Testimony of Robert A. Szynski, PPRP Exhibit RAS-1. It was filed on December 17, 2019. Do you have that before you?
Yes, I do.
And was this document prepared under your direct control or supervision?
Yes, it was.
And if I were to ask you the same questions today, would your answers be the same?
Yes, they would.
Are these responses true and accurate to the best of your knowledge and ability?
Yes, they are.
And at this time, Your Honor, I would like to enter PPRP Exhibit 1 into the record.
Any objections? Hearing no objections, PPRP Exhibit 1 is admitted into the record.
Mr. Szynski, do you have before you a document entitled the Secretarial Letter? It was filed 12/17/2019, and it's dated the same date. It also has a PPRP Exhibit RAS-2 on the right-hand corner.
Yes, some of these I've digitized, though. I've not printed out all of these, just to note.
All right, thank you. Was this document prepared under your direct control or supervision?
Yes.
And is it accurate? Is it the same? Is it a depiction of the letter that was signed by the 7 reviewing state agency
Yes.
heads?
Yep.
At this time, Your Honor, I would like to enter the secretarial letter into the record as PPRP Exhibit 2.
Any objections? Hearing none, PPRP Exhibit 2 is admitted into the record.
Do you have before you a document entitled Initial Recommended License Conditions, PPRP Exhibit RAS-3, which was filed 12/17?
Yep.
Was this document prepared under your direct control or supervision?
Yes.
Thank you, Your Honor. Thank you, Mr. Szynski. At this time, I would like to enter into the record PPRP Exhibit 4.
I think that's 3.
I apologize. PPRP Exhibit 3.
The initial recommended license conditions, correct?
Yes, Your Honor.
Okay, any objection to PPRP Exhibit 3? Hearing none, PPRP Exhibit 3 is admitted into the record.
Mr. Szynski, do you have a document in front of you called Draft Project Assessment Report for the Morgnec Solar Project, Morgnec Road Solar Project, dated December
Yes.
17? And was this document prepared under your direct control or supervision?
Yes.
And do you have any corrections at this time to make to this document?
No, I don't.
At this time, I would like to enter PPRP Exhibit 4 into the record.
Any objections? Hearing none, PPRP Exhibit 4 is entered into the record.
And Mr. Szynski, do you have a document entitled Appendix A to the Project Assessment Report, responses to data requests in front of you?
Yes.
Are these the accurate depiction of what you received on behalf of PPRP in response to PPRP data request via email?
Yes, they are.
At this time, Your Honor, I would like to enter the Appendix A to the PAR as PPRP Exhibit 5. I'd like to enter that into the record.
Any objections? Hearing none, PPRP Exhibit 5 is admitted into the record.
Mr. Szynski, do you have a document entitled Appendix B Glare Analysis, which was included in the PAR as Appendix B in front of you?
Yes.
And who prepared this?
Peter Hall, Dr. Peter Hall did.
And were you involved in the preparation of it?
Yes.
And is this a true and accurate depiction of what was determined in the glare in this analysis?
Yes, it is.
At this time, Your Honor, I would like to include PPRP Exhibit 6 into the record.
Any objections? Hearing none, PPRP Exhibit 6 is admitted into the record.
Mr. Szynski, do you have a reply testimony of Robert A. Szynski document in front of you?
Yes.
And was this document prepared under your direct control or supervision?
Yes.
And if I were to ask you the same questions today, would your answers be the same?
Yes, they would.
And are your responses true and accurate to the best of your knowledge and ability?
Yes, they are.
Your Honor, if I could have PPRP Exhibit 7 entered into the record.
Any objections? Hearing none, PPRP Exhibit 7 is admitted into the record.
Mr. Szynski, do you have a document entitled Applicant Responses to Data Request? And then in the upper right-hand corner, it has PPRP Exhibit RAS-5, which has now been corrected to -8.
Yes.
What does it include? Does it include responses to data requests by the applicant?
Yes.
And are these a true depiction of what you received via email from the applicant?
Yes, they are.
Your Honor, at this time, I would like to enter PPRP Exhibit 8 into the record.
Any objections? Hearing none, PPRP Exhibit 8 is admitted into the record.
Thank you, Your Honor. Mr. Szynski, do you have a document in front of you entitled Kent County Responses to PPRP? And then it has a header in the right-hand corner, PPRP Exhibit RAS-now-9, corrected to -9.
Yes.
And are these responses from Kent County a true depiction of what you received via email from the applicant?
Yes, it is.
I apologize.
Oh.
From Kent County?
Sorry. Yes, it is.
Your Honor, at this time, I would like to enter into the record PPRP Exhibit 9.
Any objections? Hearing none, PPRP Exhibit 9 is admitted into the record.
Mr. Szynski, in front of you, do you have a document entitled KCPA responses to PPRP DR. Begging your indulgence, just 1 minute, Your Honor. Could I have a couple minutes real quick on this? I need to make sure something's right with this document.
Sure.
Thank you. Thank you, Your Honor. I didn't want to misstate anything on the description here. Mr. Szynski, if you could flip to a document entitled PPRP Data Request Number 1 to the Town of Chestertown. In the upper right-hand corner, it has PSC case number 949, PPRP exhibit RAS-8, which we have now changed to 11. Do you see that? You have that, Mr. Szynski? Your Honor, what did I apologize. I've got all these data requests. I'm afraid I have them with the wrong exhibit. So I just wanted to make sure I had everything correct for the record. Could you please let me know what the last exhibit I just entered into the record was?
Well, you didn't finish, I don't believe, entering Exhibit 10. And I wanted to clarify, it was RAAS-7. We've changed that to 10. But in your description on your exhibit list, you added that they were KCPA responses to PPRP DR1 and Kent County DR2. And I'm not sure I understand the addition of and Kent County DR2. Do you mean in this one document, there's also...
No, Your Honor, I was misstating. That's the problem.
Okay, so you shouldn't have added and Kent County DR2?
No, Your Honor.
Okay.
PPRP.
The document is 20 pages consisting of responses, KCPA responses to PPRP DR1, correct?
Yes, Your Honor.
Okay. And I believe you asked the witness about it, but why don't we go over that again?
Thank you, Your Honor. Thank you for your patience. Mr. Szynski, do you have before you a document with entitled Morgnec Road Solar Project PPRP DR number 1 to KCPA? And in the upper right-hand corner, it has PPRP exhibit RAS-7, which we are now changing to 10.
Sorry, is on mute. Yes, I do.
And is this an accurate depiction of the document that you received from KCPA in response to PPRP's data request?
Yes, it is.
At this time, Your Honor, I would like to have this document, PPRP Exhibit 10, entered into the record.
Any objections? Hearing none, PPRP Exhibit 10 is admitted into the record.
Mr. Szynski, do you have a document in front of you entitled PPRP Data Request Number 1 to the Town of Chestertown? And in the upper right-hand corner, it has PPRP Exhibit space RAS8, which we are now changing to 11.
Yes, I do.
And is this document an accurate depiction of the responses that were provided to PRP via email that you received?
Yes, it is.
At this time, Your Honor, I would like to have PPRP Exhibit 11 entered into the record.
Any objections? Hearing none, PPRP Exhibit 11 is admitted into the record.
And Mr. Szynski, do you have before you a document entitled Supplemental Testimony of Robert A. Szynski?
Yes, I do.
And was this document prepared under your direct controller supervision?
Yes, it was.
And if I were to ask you the same questions today, would your answers be the same?
Yes.
And are your responses true and accurate to the best of your knowledge and ability?
Yes, they are.
At this time, Your Honor, I would like to enter PPRP Exhibit 12 into the record.
Any objections? Hearing none, PPRP Exhibit 12 is admitted into the record.
And Mr. Szynski, do you have before you a document entitled Revised Recommended License Conditions dated 1 October 2021 before you?
Yes.
And were these filed by PPRP on October 20th, 2021?
Yes, they were.
At your, was this document prepared by you or under your direct control or supervision?
Yes, it was.
Your Honor, at this time, I would like to have PPRP Exhibit 13 entered into the record.
Okay, can I clarify? This was part of the settlement that was entered as an applicant exhibit. Didn't you also file a red line version, or am I mistaken?
Yes, Your Honor, I did. I did not know. If you want me to include that into the record, I can do so as well.
Well, how about since let me just pull up the set that is attached to the settlement is not redlined. So why don't we make PPRP Exhibit 13 the red line version?
That's fine, Your Honor.
That was also filed the same day.
Yes, Your Honor.
Okay. And does Mr. Szynski have that in front of him, the red line version?
Yes, I do.
Then you can go ahead and proceed. I just want to make sure he had that too.
Mm-hmm.
And Mr. Szynski, is this an accurate depiction of the revised recommended license conditions that were filed on October 20th and that were a part of the proposed settlement agreement?
Yes, they are.
At this time, Your Honor, I would like to enter PPRP Exhibit 13 into the record.
Any objections? Hearing none, PPRP Exhibit 13 is entered into the record.
And finally, Your Honor, finally, Mr. Szynski, do you have before you a document entitled The Supplemental Rebuttal Testimony of Robert A. Szynski with PPRP Exhibit RES dash what used to be 4, but we're changing to 14.
Yes,
And was this document prepared under direct control or supervision?
yes,
And if I were to ask you the same questions today, would your responses be the same?
yes, they would.
And are your responses true and accurate to the best of your knowledge and ability?
Yes, they are.
At this time, Your Honor, I would like to request that PPRP Exhibit 14 be entered into the record.
Any objections? Hearing none, PPRP Exhibit 14 is admitted into the record.
And also, Your Honor, this morning I provided everyone with the attachment to PPRP 1-4 provided by the applicant, which is a letter correspondence from MHT. It is dated July 17, 2019. If I could have that entered into the record.
Okay, and just to, so we're clear, this would have been pre-pandemic and people would have received hard copies because you said that it was filed inadvertently without this attachment.
Yes, Your Honor. So it was filed as, I mean, it was sent to all the parties as part
It just
of,
wasn't e-filed.
right, Your Honor, because it was
Okay.
it was sent as part of a DR response.
Okay, so any objections to PPRP Exhibit 17? Hearing none, PPRP Exhibit 17 is admitted into the record.
Thank you, Your Honor. At this time, Mr. Szynski is available for cross-examination.
Okay, KCPA, Mr. Drummond.
Thank you, Judge Lars. Let me first mention that I have emailed several documents to Mr. Szynski and all the other lawyers. Mr. Szynski's, I got an email response from him saying he's out of the office, so I don't think he got it. Perhaps someone can get them to him. They are a copy of his testimony in the Biggs Ford's case and a copy of PPRP's response to a data request from Kent Conservation.
Your Honor, if we could just ask Mr. Szynski what he has before him and verify he has it.
Okay, and if not, then you'll be able to get it to him, right?
Yes, Your Honor.
I am opening up email now and I see the first one sent to me at 3:32. And it is PPR response. Oh. It's opening now.
So, Mr. Szynski, you have your Biggs Ford testimony. You have your responses to KCPA. PPRP's responses. What else was there that he needs to have before him, Mr. Drummond?
That's all I emailed, plus
All
his
right.
testimony, obviously. Okay,
Right.
Mr. Szynski, as you know, my name's Chris Drummond. I represent Kent Conservation and Preservation Alliance. I'll direct your attention to your direct
Sorry,
testimony.
Mr. Drummond, I'm still trying to open up those documents.
Get to them in a bit. You don't have to do it just now.
Okay.
Looking at your direct testimony from December of 2019, beginning on page 3, line 20, actually 20 and 21.
Okay, can you again tell me where you're looking, please?
Page 3, lines 20 and 21.
You're breaking up a little bit. Page 3,
20 and 21.
and this would be in my direct testimony,
Correct.
20 and 21. Okay, I am there.
Okay. And you refer to the area near the project along Morgnec Road as a commercial and industrial mix. Do you see that?
Yes, sir, I do.
And were you present when I was asking Mr. Stevens about the commercial or industrial mix
Yes, I was.
across the street from Morgnec Road?
Yes, I was.
And is there anything about my questions or Mr. Stevens' responses with which you do not agree?
I don't think I can answer that.
Yeah, did you just ask him if he agreed with your question?
Stevens' responses.
So, okay, so you're asking him if he agrees with Mr. Stevens's responses to your questions. Is that
I think you need me, oh,
is that what you're asking him?
Try to move things along, so let me go through them property by property. Mr. Sadinsky, are you familiar with the uses on the properties across Morgnec Road from the Clark Farm?
yes, I am familiar with those uses.
And one of those uses is a farm implement dealership. Is that correct?
That is correct, and I have shopped there.
Another use is a state highway facility, state highway administration facility. Is that right?
Yes, sir.
And are you familiar with the state's ability to ignore local zoning?
I'm not sure I can answer that.
Uh,
That implies I know regulations and I do not.
And another use is the county's Department of Public Works office and yard. Is that right?
Yes, sir.
And then finally, there is, I think, is a concrete plant. I'm not sure that they make ready mix concrete, but they make some concrete structures. Is that right?
Yes, sir.
And do you know whether or not the concrete use was preceded by about a 100-year-old brickyard?
I do not.
So you don't know whether that use preceded zoning in Kent County.
Correct.
And then also there is, of course, the University of Maryland Extension Service office along that stretch. Is that right?
I am not familiar with that office.
What the Extension Service is?
I'm sorry?
Do you know what the Extension Service is?
Yes, I do.
And what is it?
They generally work with local farmers.
I'm not hearing anything, Your Honor.
Hear that? I'm sorry.
Okay.
Maybe it wasn't directed.
I'm sorry. I thought you were saying something, but you weren't.
Page 5 of your testimony, Mr. Sadinsky.
I'm sorry, you're breaking up again. Can you repeat that?
On page 5 of your testimony,
Okay.
you report that this project will produce or generate electricity representing 2.2% of the energy generation necessary to meet the solar carve-out target. Is that correct?
I'm
Yes,
sorry.
sir.
Solar, what did you say? Representing solar what?
Carve-out target.
Mr. Court Reporter, would you suggest he turn off his camera again?
Something's happening. He's breaking up and I'm missing words.
I'll try to stay closer to the microphone.
I'm not sure that's it. I think it's something in your connection.
Mr. Sadinsky, do you recall what percentage towards the solar carve-out target was represented by the Biggs Ford solar project in Frederick County?
Yes, I believe it's 0.9%, but I think you know that.
A little under half of this project, is that right?
Yes. Fair statement.
And of course, PPRP recommended against approval of the Biggs Ford solar project, is that right?
That is correct.
In part because it represented slightly under 1%, or it would contribute slightly under 1% to the solar carve-out target. Yeah, I said in part.
Object, Your Honor. He's assuming things not into evidence. And if you're talking about somewhere in his Biggs Ford testimony, if you could provide the page and line for that.
Please, Mr. Drummond.
You look at your direct testimony, Mr. Sadinsky, in the Big Ford's case, which I have forwarded to you and to counsel and Judge Lawrence, beginning on at the bottom of page 14, heading into page 15.
I am there.
Apology, the handwriting, I believe, is mine, so you can ignore that. And you see, we were correct in our belief that Biggs Ford Solar represented 0.9% of the solar carve-out on the bottom of page 14. And you then go on to say that because the solar carve-out has gotten bigger, the percentage represented by Biggs Ford would be even smaller than 0.09%. You see that?
Yes, I do.
My question to you is whether that relatively small contribution to the solar carve-out was part of the reason that PPRP recommended against the Big Ford solar project.
No. I would say the 4 reasons are stated in the secretarial letter. I mean, that's just stating fact of what the RPS, that project would contribute to the RPS.
Size of a proposed project is irrelevant as PPRP and the 7 secretaries balance the need or convenience of the project versus local impacts. Is that true?
Can you repeat that? You broke up in the beginning again.
So do I understand that the size of the project and its contribution to the solar carve-out target is not part of the balancing that PPRP and the secretaries do when they're balancing the need or convenience of the project against local impacts.
I would agree with that statement.
Doesn't matter how big it is.
Correct.
So that I'm clear, 50 acres of prime farmland versus 300 acres of prime farmland is not a difference of significance to PPRP or the 7 secretaries.
What do you mean significance?
Significance in balancing the convenience or need of the project against local impacts.
Objection, Your Honor. He's offering, he's asking a question that's stating something that was never the testimony of Mr. Szynski. He did not say that it was part of the balancing. He said it wasn't part of the recommendation.
Mr. Drummond, do you want to back up and ask about balancing?
I did, but I'll try again.
Thank you.
I thought, Mr. Szynski, we had agreed, or thought you testified that the contribution of a project to the solar carve-out target is not part of the balancing that PPRP must do when it considers the necessity or convenience of the project against or in relation to, let's not say against, in relation to local impacts.
Again, I'm not sure what you mean by balancing. The balancing?
7-207 criteria that must be taken into account.
Your Honor, objection. I believe if you, can I go ahead and explain myself?
Well, I think that there's maybe some confusion. The 7207 is the statute pursuant to which the commission considers an application. PPRP provides evidence as to those factors. I don't know. There's nothing in the record that PPRP conducts a balancing, as you're asking.
It must do so, and the 7 secretaries must do so when they come to a recommendation.
That's your assumption. That's not within my knowledge. So, and I get from the witness that that's not within his either, since he seems confused by the word balancing.
Your Honor, some of the confusion may be that 3306 says that we provide a recommendation for approval with conditions or denial of a project, a recommendation. That does not imply that we go through a balancing. That was my objection.
And based on that objection as to her legal interpretation, I think you need to move on to your next question for Mr. Szynski.
Well, Mr. Szynski, you testify in, I guess I better find the page, bear with me. Page 16, line 9 of your direct testimony in this case.
Okay. So in this case, in Morgnec, direct testimony,
Correct.
page 16.
You say that this is a difficult case, particularly given the proposed project's potential visual impacts and the future economic development plans of Kent County and Chestertown. Do you see that?
Yes, sir.
So if you're not I don't know what other word to use, but balance. If you're not considering, let's use that word. If you're not considering the convenience and necessity of the proposal and the countervailing impacts upon a local jurisdiction, why would you say that this is a difficult case?
I'm not sure we determine convenience and necessity.
Consider then, when you're not, other than the impacts upon the locality.
I'm sorry, you're breaking up in the beginning again.
What do you consider then, other than the impacts on the locality?
Well, as you know, PPRP does the environmental and socioeconomic impacts for a project. So we look at all the environmental factors, and then PPRP makes a recommendation. The decision is not made from PPRP. We make a recommendation to the reviewing state agencies.
And presumably you offer some guidance to the secretaries when they make their recommendation.
We offer facts. This is true.
Don't you make a judgment, Mr. Sadinsky, when you describe the facts producing a difficult case? Isn't that a judgment?
I'm not sure. A judgment. I'm not sure it's a judgment. It's a recommendation. We're not judging the case.
Page 7 of your direct testimony.
I'm there.
In the middle, line 13, you refer to the mitigation of cultural resources. Do you see that?
Yes, that's referring to Mr. Dr. Hall's testimony. If you look up above, as discussed in testimony of PPRP witness.
And how, if at all, has PPRP proposed to mitigate impacts to cultural resources, Mr. Sadinsky?
I think that would be best answered by not myself, by Dr. Hall, who is our expert in that area. You're breaking up again. I'm sorry.
I don't think she's testifying. Maybe I misunderstood.
No, Dr. Peter Hall, he testified yesterday.
Oh, Peter Hall. I thought you said she.
Yeah.
I misunderstood. So you don't know how cultural resources are proposed to be mitigated if this project is approved?
That isn't my area of expertise. I'm sorry.
Can you direct my attention to any of the recommended licensing conditions, whether or not you're an expert in that, which seek to mitigate cultural impacts to cultural resources?
If I can have a minute to go through them. Some of it refers to condition 26, archaeological discoveries. which would imply cultural resources.
Anything else?
Your Honor, I want to make sure I get every word that Mr. Drummond says, but sometimes it like misses spots, like when he first starts to talk. I'd like to try again without the video.
Do you understand, Mr. Drummond? Your audio is better when your video is off for a clear transcript.
We'll try it. If it's not better, I'll tell you.
Anything else, Mr. Sadinsky?
No, sir. I would relate to condition 26.
Mr. Sadinsky, on, you look at page 14.
The direct?
Yes.
Yep.
Beginning at lines 14. There's a discussion about whether or not the project will impede within the critical area. Do you see that?
Yes, sir.
And are you now aware that Kent County has adopted its new GIS-based critical area maps?
Yes, sir.
And did you hear the testimony from Mr. Clark that a revised plan has been developed?
Yes, sir. I did.
Have you seen that plan?
No.
Your knowledge, has anyone seen that plan?
I
Knowledge,
assume, oops, I'm sorry.
to your knowledge, has anyone at PPRP seen that revised plan?
Not to my knowledge.
So at the moment, we don't know whether the proposal moves solar panels to another place on the property that may or may not require the removal or a forest cover. We don't know that presently. Is that right?
Well, in response to the applicant's DR for 4.7, they did state that they're going to reconfigure and move out of the critical area for all panels based on the new maps.
Does not that response to 4.7 also indicate that they'll be removing some trees and will then need to be compliant with the Forest Conservation Act? I may be incorrect, but I think it says that. You recall that, Mr. Sadinsky, and their response to data request 4.7? Did you hear that question, Mr. Sadinsky? Am I not being heard?
I don't think he hears you.
You're fine, Mr. Drummond. I don't think he heard you.
Mr. Sadinsky, did you hear the last question? I don't think he's hearing me either. Are you in the same building with him?
We are.
Yeah.
Is it okay to go?
Can you just check with him and see what happened to his? Yeah,
Yes,
'cause I
sure.
don't think he's hearing.
Yeah, Mr. Drummond sounds a lot better without the picture. It's coming through good.
Well, you just don't want to look at my mug anymore. I get that.
I don't think so. That's not it.
Mr. Sadinsky, you can't hear me, correct? Okay. Yeah, just hold tight a minute.
Your Honor, I'm just trying to test.
He's going to try to drop off and rejoin.
Okay, he's going to try to rejoin to see if that fixes it. We've been trying to fix the sound.
Okay. Do you need 5 minutes or so?
Yes, Your Honor, please. Apologies, we're
Okay.
having some technical difficulties.
We'll stand in recess for 5 minutes. Thank you.
Here we go. See if they
Can you all hear me? Can you all hear me?
Bob, I can hear you.
Oh, very good. Okay.
Why don't you see if your video works as well? Okay, it's working. Thanks, Bob.
Sorry to refresh and reload and enter again.
We're recessed for about 3 more minutes.
Oh, okay. I'll go on mute. Thank you.
Mr. Szynski, were you able to fix your audio?
Hopefully, Your Honor, can you hear me?
I can, and you can
Oh,
hear me?
wonderful. I must have had too many windows open. I had to reload everything, so I apologize.
No worries.
I'm here, Your Honor. Doug, the reporting.
Okay, I'm just waiting for Ms. McLemore. Well, not only for her, but mostly for her, since it's her client being
Your Honor,
questioned.
I'm here. I'll turn on my video.
That'd be great. Thanks. Okay, we're back on the record in case number 9499. I apologize. I don't recall what, I think we were still talking about response to DR 4-7.
Right, Your Honor. Mr. Sadinski, this is Chris Drummond. You referred to the applicant's response to PPRP's data request 4-7. And in that response, you were correct that the applicant says it will not site solar panels within the new critical area designation. The applicant will provide PPRP with a revised site plan once available, and that is the site plan that you indicated you have not received. Is that correct?
That is correct.
And then the next data request was, will the linear stand of trees on the northwest side of the property that appear to mark an old property line be removed? If so, please provide an updated site plan. Do you recall that data request in 447?
Yes, sir.
A response was, a portion of the linear stand of trees will be removed to offset the loss of 16 acres associated with the new critical area designation. The applicant will provide PPRP with a revised site plan once available. Recall that response.
Yes,
Okay, and you've not received a site plan that shows the removal of the linear stand of trees and how that is to be, how that removal of trees will be addressed through a forest conservation plan.
that is correct, but I don't know if it's considered forest either. So
Then, but so we don't know whether Forest Conservation Act will apply.
that is correct.
How is it, Mr. Sadinski, that PPRP can assemble all the information necessary to make recommendations to the secretaries when it does not know the configuration of the proposed solar array?
Site plans continuously change through the process. I don't know of any projects that I've been involved with, which has probably been 12 or 13 solar projects that have had a full county approval prior to an evidentiary hearing. So therefore, the county, to my knowledge, has always made changes to every site plan that I'm aware of. It may be small.
That's not my question, Mr. Sadinski. My question is, let me back up. Perhaps it's an assumption and it's mistaken. And you can correct me if I'm mistaken. The applicant is obliged to provide PPRP with the project. Am I right?
Correct. Yeah, environmental review document.
The project includes where the array will be. Is that right?
Correct.
And you now know that there may be upwards of 16 acres of the array that you have seen that will be somewhere else or not constructed at all. Correct?
Correct.
And that's of no significance to PPRP's review of the application?
The review of the limit of disturbance will not change because we have condition
I'm
two.
not asking,
page staff.
I'm not asking about post-approval conditions. I'm
Mr.
asking
Drummond, I
about,
think if you allow him to answer, I think he's trying to get you the information that will will be responsive to your question. Why don't you let him finish, and then if not, you can ask another question.
The limit of disturbance for the site cannot change. If it does, like I said, then they need to come back and receive approval by PPR, reviewed by PPRP, and then again, approved by the Public Service Commission. That's condition 2, if you look at that, please. It'd be the revised condition.
again, it's of no significance to PPRP that a revised site plan was promised in March of 2020, and yet it has not yet received it.
We have asked for that several times and not yet received it, but like I said previously, site plans always change. And I think we have, even when it comes to forest conservation, I mean, the condition is flexible enough and gives the authority back to the county to make those changes and to accept whatever FCA compliance the county satisfied with according to the state minimum standards.
Irony, Mr. Sadinsky, in relying upon the counties for the details about which you've just spoken, but basically telling the counties that they have no control over where these things go. That, I suppose that's more rhetorical than anything. I'll withdraw it. Mr. Sadinsky, on page 20,
I'm sorry, is that of his direct testimony?
lines beginning on line 6. Is the first of several references.
Are we on his direct testimony in this case?
That yes?
No one heard you say that.
I'm sorry. You have that, Mr. Sadinsky?
Yes, I do.
On line 6 is the first of several references to a 25-year life of this solar project. Do you see that?
Yes, sir, I do.
And in fact, in the recommended, or I say amended recommended licensing conditions included in your testimony, there's a reference to a 25-year period for this project. Is that right?
Was that the initial? Oh, go ahead.
No.
Those are the initial recommended conditions?
I think it was in your, take it back, in your testimony of March of 2020, I think, I take it back, you refer to a period of 25 years, at which time the town or the county could petition the Public Service Commission to terminate the use. Recall that?
Yes, I do recall that.
And in your testimony, this would be your reply testimony of March of 2020.
Let me get there first.
Don't ask me for the page. I don't have it in front of me at the moment.
I believe Mr. Drummond's talking on page 8 of his reply, if that's helpful.
And in that testimony, you acknowledge that there was some concern raised by the town and the county about the manner in which they would seek to ask the Public Service Commission to terminate the use at the 25-year mark. Is that right?
Yes.
All right. And so 25 years seems to have been the benchmark until several weeks ago when we received the proposed settlement agreement. Is that correct?
Yes.
When the termination dates are now 30 or 34 years, correct?
Correct.
Why has PPRP backed away from a 25-year lifespan for this project?
I believe the answer is in the supplemental rebuttal. Just give me a minute. Or maybe it's not. No, it's not there. Wrong one. Not to delay this, but my recollection is I think it was going to be in sync with the rewriting of the county comp plan was one thing.
Mr. Sadinsky, when was the Kent County Comprehensive Plan last adopted?
I believe Mr. Stevens said it was 2015.
That's the town.
Oh, I do not recall that. I'm sorry.
Don't know that the 30 to 34 year lifespan was tied somehow to the planning cycle of the county.
Yes, I believe we tried to do that.
But you don't know when the last comp plan was adopted by Kent County.
I'm not off the top of my head.
Sadinsky, let me try once again to test your testimony from earlier. If you go back to your direct testimony in this case, page 16, lines 14 and 15. Have that?
Yeah, I'm there.
All right. And you see that your testimony, well, you're going to tell me that, strike that. It says, as noted by Dr. Hall, PPR believes that the visual impacts will be mitigated through the implementation of enhanced landscaping to screen the site. Do you see that?
Yes, sir.
All right. So PPRP does in fact make judgments.
Judgments to the effectiveness of screening?
What else is a belief but a judgment?
Okay,
Don't just collect facts. You collect facts and then come to conclusion. By you, I mean the executive you or the imperial you, come to opinions or conclusions based upon those facts. Is that right?
seems a reasonable statement.
Now, Mr. Sadinsky, in the project assessment report, on page 11,
I am there.
.1 PPRP reports, second to last line and last line, some portion of the site is located on prime farmland. Do you see that?
I do not. Is that in the footnote?
Mr.
11.
Drummond, are you on page 11 of the PAR?
Yes. That's what I said. Now
Okay.
maybe it's an appendix. Hold on.
Is it the sentence at the end of the first paragraph under 3.1?
Yes, vegetation. First,
Oh, yes, I'm
last,
sorry. I see it now. Yep. Some portion of the site is located on prime farmland, correct.
have you since learned either between the date of this project assessment report and yesterday that in fact that some portion is 76.5% of the property?
I did hear that.
Which is essentially 75% of the prime farmland found on the Biggs Ford property, which was 100% prime.
I'm not sure of that statement. Can you say that again, please?
Biggs Ford project was located on property that was 100% prime farmland. Is that right?
That is correct.
That was significant, was it not, to PPRP and the 7 secretaries?
It was listed as one of the contributing factors. That is correct.
And this property is 3/4 of that which existed on the Biggs Ford property. Is that right?
Correct.
And yet, apparently, that was not a contributing factor in PPRP and the 7 secretaries' recommendations in this case.
I would not say that. Of course, we present the facts to the offices, to the secretaries, and they made the decision. I mean, like I said, we provide a recommendation. They make the decision.
Well, are the prime soils on this Kent County farm any less important for preservation than the prime soils on the farm in Frederick County?
I'm not sure I'm qualified to answer that.
Who is the PPRP?
Not a PPRP. It'd likely be one of our consultants.
Clear. He makes judgments, comes to opinions on some matters, but not others.
Your Honor, objection. He's badgering to some
I
extent.
am not no, that is not a badgering question.
I guess I don't understand the point of your question, Mr. Drummond. What are you trying to get from Mr. Szynski?
I'm trying to get from Mr. Sadinsky that PPRP is picking and choosing that which is important when it makes recommendations to the 7 secretaries. And when they're presented with almost exactly the same facts, in one case, they recommend denial, and in the other place, they recommend approval.
Okay, I don't think the witness testified to that.
Of course he didn't. That's the conclusion and argument I wish to draw from asking these questions.
Okay, but your most recent question was whether PPRP considers some things to be important and disregards others in its judgment, something like that.
Yes, that was the question.
Is that true, Mr. Sadinsky?
That was the question, correct?
No, is that, I know, and if you answer that question, is that true? PPRP considers some things but ignores others?
Of course not.
Okay.
I mean, we present the facts.
That's fine.
Yeah.
Mr. Drummond, next question.
Sadinsky, I'm sorry, I've misplaced. Okay, I'm sorry. I apologize for the delay. All right, Mr. Sadinsky, if you look at your supplemental direct testimony of October 20, 2021, page 5.
Yep, I am there.
Beginning at line 18, you testify regarding essentially what are legal matters. Do you agree?
No. Why would you? Doesn't seem like a legal argument to me.
To whom would Morgnec Road Solar have argued that Kent County landscaping standards are not appropriate?
I'm sorry, can you please repeat that? You broke up all the way through that question.
To whom would Morgnec Road Solar argue that the adoption of the Kent County landscaping standards were not appropriate?
Before the commission.
It's in essence a legal argument, is it not?
I can't interpret that. I don't know if it's a legal argument or not.
Is this part of the facts that PPRP assembles in making its socioeconomic assessment of a project?
Again, I'm not sure of the question.
Clear. How is that statement related to PPRP's statutory obligation to assemble information and assess socioeconomic impacts?
I think it relates to the increase in setbacks going from up to 200 feet, along with the increased vegetative buffer. It's just stating the facts that the settlement agreement increases all those.
You're giving props to the applicant for agreeing to something it may not have to do. Is that correct?
Yes, I guess, I think the question is, could they have argued before the Public Service Commission that the new ordinance did not apply? Is that what you're asking?
That's what you've said in your statement, and
Yeah.
am I correct?
Yes,
And on
yes.
what basis do you, perhaps Ms. McLemore needs to answer this question, on what basis would the applicant be able to argue to the Public Service Commission that it need not comply with a local landscaping standard?
You're asking me or Ms. McLemore?
If I could, Your Honor, I would object to the extent that it does call for a legal opinion. I believe that he can answer partially as far as the factual, but as far as the legal opinion, I would object.
Okay, it sounds to me that the witness knows that the applicant could have argued that the application of a newly enacted ordinance adopted by a party in the CPCN proceeding, Kent County, with the potential involvement of another party, KCPA, in its development was not appropriate. I guess he went on, there was also testimony, though, that Mr. Sadinsky is also aware that Morgnec Road Solar could have argued that the ordinance didn't apply because it was adopted, I guess, after the date of the application. And I would assume he was advised of that by his counsel. So I don't know really what else you're.
My point here entirely is to suggest that PPRP is simply a neutral collector of information, which it passes on to the secretaries for the secretaries to make a recommendation, is fictional. And
Okay, you can make that argument in your post-hearing brief, Mr. Drummond. But I don't see anything in his testimony that's, which by the way has already been entered into the record, is improper or goes beyond his knowledge.
Mr. Sadinsky, direct your attention to page 8 of your supplemental direct testimony. Line 5. You refer to you say that the entrance into Chestertown along Morgnec Road is not currently a pristine entryway. You see that?
Yes, sir.
And that's because there is a farm implement dealership, University of Maryland Extension Service office, MBA facility, a county DPW facility, and an old brickyard that's now used for some sort of concrete structures. Is that right?
Yes, it has industrial look. This is correct.
Well, it doesn't have an industrial look on the right side, does it?
No, sir. Well, coming
Are
into
you-
town on the right side, it does not.
Are you familiar with the entranceway to any rural town on the Eastern Shore or elsewhere that is quote unquote pristine?
Yeah, I think the town I live in, Churchill, the next town south, Chestertown. I would argue that.
That's got a school, doesn't it?
Yeah,
Got a series of it's got a large convenience store with a lot of signs plastered all over it that are probably illegal, but anyway, a lot of signs. Is that right?
it does have a lot of signs. This is correct. Offering free coffee. This is true.
I correctly understand that because the entranceway is not, quote, pristine, that putting 200 acres of solar panels immediately across the street will not be a detriment to that entranceway.
That was never stated in there. It just, again, identifying facts, saying coming into town on the left-hand side, it has industrial look.
Mr. Sadinsky, in the Biggs Ford case, PPRP, through the secretaries, recommended a denial. And an important element of that recommendation was the property's designation as a PPA. Is that right?
There was 4 factors, not just one.
Important factor, or okay, I'll say a factor.
Yes, correct.
And another factor, in addition to PPA, prime farmland, was the opposition of the county and the town of Walkersville, right?
And local opposition also.
Right.
Yeah.
What was the fourth?
That is a good question. Not consistent with the county comp plan.
Right. So let's take those factors and apply them here. Rather than 100% prime farmland, it's 76.5% here. Is that right?
Correct.
It's not in a PPA, but it is designated by the county as a PFA, correct?
Correct. Priority funding area, correct. Yeah.
Right. And to your knowledge, is it true that the Eastern Shore counties, by and large, have designated all of their ag and rural as PPA?
I would not know that. I'm sorry. It's outside my expertise.
You know that Frederick County has been more selective than the Eastern Shore counties in designating PPAs, largely because it's a suburban county.
Objection, Your Honor. He's
Sustained.
I asked if he knew.
You asked if he knew and he said no, and then you asked another question about the same topic. Sustained.
Third factor, it was opposition from the county, the nearby town. By the way, how far away from Walkersville was Biggs Ford?
I'm sorry, you're breaking up.
How far away from Walkersville is the Biggs Ford project?
I don't recall, but I think it's in the Walkersville growth area. But that may be correct. I'm sorry, that may be incorrect.
So in the Biggs Ford case, local opposition, county opposition, and town opposition, correct?
Correct.
You have the same thing in this case, is that right?
No.
What don't we have in this case?
Again, you're not in a PPA.
No. I understand that. I've gone to the third factor. We've already been past the PPA, PFA, prime farmland, all of that. Now we're on to the third factor, which was town, county, and local opposition to Biggs Ford.
Mm-hmm.
And we have the same thing here. Is that in Kent County? Is that right?
I believe in Biggs Ford, no one spoke in favor of the project except the landowner, which is not the case with this project.
Kent County is opposed. The town of Chestertown is opposed. And a citizens group in the name of Kent Preservation Alliance is opposed.
Correct.
Right? And the fourth factor, remind me?
Prime Ag, County comp plan, I think was the fourth.
County comp plan.
Yep.
And you've heard our Mr. Stevens' testimony today, correct?
Yes,
That at presently, utility scale solar is presumptively inconsistent with the comp plan, Kent County comp plan. You heard that testimony.
yes.
Okay. That's all the questions I have. Thank you.
Mr. Yeager, do you have any questions?
Your Honor, can I ask a question? They keep
Yes.
using the word big sport, but I don't know what spell the last name. Big what?
Well, the first one is BIGGS. Second word, FORD. Biggs Ford.
Thank you.
Mr. Yeager, do you have any questions for this witness?
Yes, Mr. Sadinsky. My name is Tom Yeager. I'm the county attorney for Kent County. And as you know or should know, the county is opposed to this project. I'm going to direct your attention to page 18 of your direct testimony, lines 8 through 13.
Direct testimony, page 18.
Yeah,
Okay.
yes. And in that, you note that I think you adopt what Mr. Stevens states. You say land use such as the solar arrays aligns well with the plan for future annexation outlined in the Chestertown Comprehensive Plan. The applicant asserts that given the finite lifespan of the solar project, the project is consistent with the comprehensive plan and will allow for planned growth in Chestertown in 20 years or more. Does that accurately reflect what's set forth in your testimony?
Yes, sir.
And throughout your testimony, I think in some other places, you refer to a lifespan of 25 years. Is it fair to say that when you were giving your testimony, you did so with a belief or an assumption that the lifespan of the project would be about 25 years?
To my knowledge, lifespan of most solar projects I've worked with has been stated to be 30 years.
Right, but throughout your testimony, you don't use 30 years. When I look at your testimony, I see 25 years noted in a number of times. For example, 25 years is set forth on page 19, line 11. 25 years is set forth on page 20, line 5. 25 years is on line 6 on page 20. Page 21, 25.
Okay, I think
on line
you've
17.
provided him with the examples.
So based on that, would you agree with me that for purposes of your testimony, you were considering a lifespan of about 25 years because you used that number consistently throughout?
Oh, I think we lost him.
Okay. 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 Are you there? You with me? Okay.
Yep. Sorry, you were lagging.
And in this particular project, you know now, and I think you just said the lifespan's more like 30 years. And
Yes, sir.
the decommissioning proposals are at least 30 years out. So would you agree that decommissioning is something that is likely to be at least 30 years out rather than 25 years out?
Yes, I would agree.
Right. And you would also agree that we have yet to see a utility scale solar project decommissioned in the state of Maryland.
Correct.
So despite our best hopes and plans, we really don't know what's going to happen 30 years from now, do we? Because we've never gone through this before.
That is why the decommissioning plan or decommissioning condition that we're recommending is adaptive.
Look, what I want you to do is answer my questions. Then your attorney will have an opportunity to ask you redirect if you want to talk about something else. But what I need you to do is answer my question.
I'm trying.
Okay. So you would agree that there's a lot of uncertainties 30 years from now?
Yes, sir.
Because we've never had a decommissioning before. And you would agree that if there are issues with decommissioning and environmental issues that need to be addressed, and I take it that you probably are aware with that, you've dealt with landfills and other things, or maybe have some knowledge, that you know that decommissioning, there can be issues that happen during decommissioning, correct?
Correct.
So the best case scenario is around 30 years. Would you agree?
Best case scenario for,
Decommissioning would be 30 years.
well, that's assuming that the panels won't be changed out, there's not repowered, that no changes are made to the site.
Well, you would agree with me that if this project gets built, this utility scale solar project gets built, it's going to take a few years to get it built, correct?
In my knowledge, yes, it does take a while. I would not say years. That's really up to the applicant.
And then once it's built, it has a life of at least 30 years.
Again, unless they replace panels, because the life of a panel is generally 30 years.
Okay. Well, let's just say we don't replace any panels for purposes of this discussion.
Mhm.
You're looking at 30 years. And then after that, when you start the decommissioning process, there's a lot of uncertainties as to when that process will be successfully concluded. And there are also uncertainties as to whether or not this property will be suitable for certain development after decommissioning.
Was that a question?
Yes.
No, not agreed.
You don't agree?
Because there's no evidence that shows that the property will not be suitable. And suitable in what way? Suitable for farming, suitable for houses?
Well, you talk about in your testimony, you do acknowledge that this property is considered to be a growth area for Chestertown.
I'm sorry, you're fading away.
You
It's
do.
what?
Sorry, I know my voice is not up to snuff today, and I apologize for that. You would agree with me, and I think it's pretty much undisputed, that Chestertown has looked at this property as a growth area. And I think you've seen that if you've been here for, I believe you have, that you have on one end, you've got water. The other side, you have property that is ag preservation. The other side, you have a development pattern that really isn't suitable for more growth. So you would agree with me that this property is a designated growth area for Chestertown.
I do not have the expertise to make that yes or no. I just do not have the expertise.
Well,
It would have been Dr. Hall.
Well, would you agree that that's what that's the town's position? Would you agree at least, concede, that it's the position of the town of Chestertown, that this property is part of their designated growth area?
Yes.
Okay. And would you agree that Kent County sees this property as a designated growth area for Chestertown?
Yes.
And would you also agree that with respect to this designated growth, we're looking at residential and or mixed use type of growth?
That is my understanding.
And so we're not really looking at if it's going to be growth, it being farmland. 30-year, or it's going to be farmland. Would you agree with that?
I don't know. I don't have that expertise again. I don't know what's going to be in 30 years. You asked me to predict. I couldn't do it before and I can't do it now. So.
And would you agree that if there are uncertainties with decommissioning and problems with the decommissioning, we don't know exactly when this property would be suitable or if it would be suitable for a growth of residential mixed-use development?
No, I don't agree with that.
You know,
You're assuming that it's not going to be suitable. We don't know if it's going to be suitable or not. And I would, there's no evidence to suggest otherwise.
Correct. We don't know because we've never decommissioned one of these plants again. But you make the assertion that this is consistent with the Chestertown Comprehensive Plan because in 20 to 25 years, we can develop this property as the plan intends right now. But we don't know that. I think you just admitted that. We don't know that. Would you agree with me there?
Can you repeat the question?
Okay. You would agree that we do not know if in 25 years from now that this property could be developed consistent with the Chestertown Comprehensive Plan for residential or mixed-use development.
Just to correct you, would be 30 or 34 years based on the revised conditions? And I would agree.
You would agree after 30 to 35 years?
30 or 34 based on the revised condition.
Okay, but you would agree that if you're looking at a period of 20 to 25 years, as you opined in your direct testimony, that that's really not feasible?
What's not feasible?
To develop this property for residential or mixed use within that time frame.
Again, I'm not sure what I mean, that's really up to the Public Service Commission. We only send it a recommended condition. I'm sorry, I'm not understanding.
I understand that, but what you have done is provided direct testimony, and which I take it is to forward an argument or a recommendation that putting the solar, utility scale solar array on this property is compatible with the Chestertown Comprehensive Plan. A plan that calls for this property to be developed residentially or for some type of mixed use. So are you now, you want to withdraw that testimony now?
No.
Your Honor, if Mr. Yeager could cite to where exactly he says that it is consistent with the comp plan in his direct.
I'm looking at the question. This is on page 18. In contrast to the county's position, the direct testimony of Joseph Stevens on behalf of the applicant indicates that the construction of the proposed project would be consistent with the local comprehensive plans. What does Mr. Stevens predicate this position? And so then this witness goes on to essentially quote Mr. Stevens and agree with Mr. Stevens and to adopt Mr. Stevens's position as his. In my understanding from past witnesses here, that in Public Service Commission's proceedings, it's perfectly acceptable for one witness to adopt another witness's testimony, and therefore I can cross-examine this witness
Mr. Yeager,
testimony that he's adopting.
Mr. Yeager, if you look at his testimony on page 18, I believe there's a however on line 13. Maybe perhaps if you have him read it and then ask the question.
Reed says, however, in its response to Kent Preservation Alliance's data request 1-14, the applicant indicates that it is not limiting the lifespan of the project. Without a clearly proposed prescribed lifespan, it is unclear how the project would allow for the future growth of Chestertown.
Okay, I'm pretty sure the witness was confused by the last few questions you asked. Do you have a question now? Based on that testimony you just quoted.
Well, Mr. Sadinsky, am I correct that you were saying that because the applicant did not give a lifespan, you could not opine or make a recommendation as to whether or not this project would allow future growth of Chestertown?
I think it comes down to a matter of timing. That's what's implied by that sentence. And let me read it. Without a clear proposed prescribed lifespan, quotes, it's unclear how the project would allow for the future growth of Chestertown. So it has no hard date.
Okay. But even with a hard date, we still have all the uncertainties of decommissioning. Because we've never decommissioned a plant in Maryland before, we don't know exactly what that's going to bring, do we?
I'm not sure what you're referring to. What uncertainties?
Well, there could be environmental concerns, could there not? From this property being used for the solar arrays for 30 years? Would you agree with me? A lot can happen in 30 years?
Okay, what am I agreeing? Yes, a lot could happen in 30 years.
Hang on a minute. Mr. Yeager, you've got to stop asking compound questions, okay?
I'll
One
do
question,
at a time.
let him
Here's
answer.
question number one. Here's question number one. Would you agree that there are environmental concerns? Could be environmental concerns after this property being used for its intended purposes as a utility scale solar generating facility for 30 years.
So you're asking if prior to decommissioning, are there environmental concerns just because the panels are there?
Could there be?
There's no evidence. There's no scientific studies that have shown that throughout the country.
Well, you've just testified that we have not decommissioned under today's regulatory environment a utility scale solar project. Is that correct?
Yes, in Maryland.
And so under today's regulatory environment, there are a lot of uncertainties as what's going to happen 30 years from now because we've never gone through it.
Again, defining uncertainties. Yeah, there are uncertainties, generally speaking.
Okay. I don't have anything further for the witness.
Okay. We're going to take a recess now. Mr. Hicks, you will have the opportunity to cross-examine Mr. Sadinsky tomorrow. Mr. Sadinsky, you could be with us tomorrow morning at 9?
Yes, I can be.
Thank you. Are there any other housekeeping matters?
I would just say, if it helps, Mr. Sadinsky, my probably won't be lengthy tomorrow based upon the question by the other two counsels.
That is helpful. And then from there, we'll go to KCPA's 3 witnesses.
I do have a question regarding my witness. When we had, I think it was Mr. Yao, when he was testifying as to the zoning of the property, he falsely asserted that the zoning was industrial. And I attempted to, through cross-examination, get the correct zoning of the property into evidence. I can do that through Mr. Mackey, but I believe that that's in his direct testimony. And is there any opposition that we can just stipulate as to what the correct zoning of the property is? That what is in Mr. Mackey's direct testimony is in fact the zoning of the property?
Mr. Bugelmans?
Correct zoning. That would save some time. If so, I would probably.
I know, I'm asking Mr. Bugelmans if he wants to respond to that request. I can't hear you, Mr. Bugelmans. Double unmute.
One day I'll learn. I'm sorry about that. I was trying to say that the applicant wouldn't oppose stipulating to that designation with the caveat that that zoning designation is preempted by this proceeding. But it is, I agree, he misspoke, and I think the testimony of many witnesses reflects the reality of what the designation is.
Okay, so I think we're going to agree to stipulate in Mr. Mackey's testimony with regard to, well, I don't want to overstate it. Are you stipulating to all of his testimony or just the zoning map that's apparently included in his testimony?
The zoning map, so I wouldn't have to ask him questions other than for him to say if he, gave the same answers today,
Okay.
answers today, it'd be the same. So what I would anticipate doing with Mr. Mackey would be the same litany that Mr. Bugelmans did with his witnesses, rather than having to go the extra route of eliciting from Mr. Mackey on a direct examination, the current zoning of the property to clearly establish that.
That's fine with me. And Ms. McLemore, you don't have an issue with that, do you?
No, Your Honor, we don't have an issue with that.
Okay, does anybody else want to be heard? Okay, we'll see everyone bright and early tomorrow morning at 9 a.m. Mr. Hicks will be cross-examining Mr. Szynski. Mr. Szynski, you are not to speak to your counsel regarding your testimony this evening. And Ms. McLemore, you're not to speak to him regarding his testimony. Thank you.
Understood.
Good night.
Thank you.
Your Honor. Thank you.
Thank you, Your Honor.
Right.
Night.